I don't know about that. That's taking So we have now made it to chapter 5 or unit 5, whichever you want to refer to it as, which is called transfer of title. And transferring title is a really, really fancy way of saying changing ownership. I mean, that's what we're dealing with here, is the changing of ownership from one person who we call a grantor. Remember that term we talked about back in chapter 2, from a grantor to a who? A grantee.
Grantee.
And so now we have decided the type of ownership this grantee is going to have and the type of ownership we're going to convey. And now this is the moment of transfer. This is the point in time where the transfer happens. And that's what we want to focus on here in chapter 5, is that one moment in time when title or ownership, title just means ownership. It's a fancy word for ownership, because the truth is there is no such thing as this. This is not a thing when it comes to real estate. That's a thing when it comes to a car. Your car has a title, a piece of paper that at the top says title. There is no such thing for real estate. There is no document that says you have title to real estate. Who of you own your home? Like, I see Angela's got her hands up, Carlene's got her hands up, Beth's got her hands up, Kenneth. Good. Who shall I pick on? Let's pick on Carlene. Oh, she's eating. I don't want to pick on her.
What's she eating?
You can pick on me. Go ahead, pick on me. I'm good.
Okay.
Pick on me.
All right. So, Carlene, I have a question for you. You say you own your home, correct?
Yes.
Okay. Prove it. I want you to prove it. I don't believe you.
I've got papers.
But what paper do you have? Show me the papers you have.
I'd have to go dig in the closet.
Okay, but do you know what papers you have that you say, these purported papers that prove
Well, I've got a copy of the deed.
So you have a copy of a deed. That's a
Deed
good
of trust.
document to have. How many of you have ever heard the word deed? She has a deed.
Yes.
That's an important document. Let me tell you what a deed says, Carlene. A deed says, I'm gonna stop the share here for just a second because I want to talk to Carlene. A deed, Carlene, says that whoever claimed that the property was theirs before you said they were giving it over to you. That's what the deed says.
Right.
But here's, so I agree, Carlene. You can prove beyond the shadow of a doubt that some person signed a piece of paper saying they're transferring ownership from them to you. That's what you
and I paid an attorney and they recorded it.
And they recorded it. And you recorded it, which is smart for you to record that. Here's what I want to ask you though. Is it fair to say then you owning it relies on the fact that they owned it before you?
Yes.
Well, then prove they owned it.
They transferred their deed over.
But how do you know they owned it?
There was a title search done.
But what did that title search show? It showed their deed, right?
Right, and that they were the first owners. It was owned by the developer before that.
Okay, so how do we prove the developer ever actually owned it?
Well, it's actually in the records. There's a chain of title.
But see, here's what's in the records. A deed. But all a deed ever says is that the person who was claiming ownership before you has relinquished their claim of ownership and transferred it over to you.
Right.
Here's the thing. We're going to chase our tail forever. You'll never actually get, here's the shocking thing, Carlene. When I say prove you own it, the correct answer is, I can't. There is no proof that you own it. How many of you that make you uncomfortable with the whole idea of property ownership right away? How many of it make you uncomfortable when somebody says you can't prove that you own your own property?
The only real proof you have of is it goes for a period of time uncontested, then you sort of kind of got it.
There you go, Rodney. Here's how we actually do property, and I'm not even making this up. This is how property ownership works. Carlene, I'm gonna be willing to make a bet and agree with you that you actually own that property. I actually do believe you that you own the property, but I don't believe you because you have a deed. Here's why I believe you. There's approximately 8 billion people on this planet, and you're the only one who says you own that property. Out of all 8 billion people on this planet, you're the only one who has made a claim to that property.
Yep.
Those are pretty good odds that it belongs to you, wouldn't you say?
Pretty good odds.
Because if it belonged to somebody else, what would they do?
They'd kick me out and say it's mine.
They would make their own claim, right? And so there's a reason I do this exercise, folks. There's a method to my madness here. The reason I do this exercise is I want to show you how important it is that Carlene took that deed that she got and took it to the county courthouse to record it. That is her making her claim in the property. The moment she took that document to the courthouse, she is claiming not for herself, but for the rest of the world that property belongs to her.
Okay.
Does that make sense for everybody?
Yep.
And if nobody, and Rodney's exactly right, if
Yes.
nobody else steps forward and makes that claim, well, by default, Carlene, it's yours. And that's how we handle property ownership. And that's why I think people get confused about this idea of transferring title, because we like things to be exact. We like things to be precise, and we like things to be always one way. And that's just not going to be the case when we start talking about transferring title to property. So let's dig into this a little bit. Title, it says, represents the bundle of legal rights. Now, whenever we give up that bundle of legal rights, we call that alienation. Alienation is just separation. Alienation means separation. So anytime you separate yourself from ownership, you have alienated the property. And you can actually do that voluntarily or involuntarily. What do you think the difference between a voluntary alienation and an involuntary alienation is?
You sell it, and involuntary is foreclosed.
You sell it, and Kenneth said you sell it versus it being foreclosed. Would one of those be voluntary and one of them be involuntary?
Mm-hmm. Yes.
They both have the same result. At the end of the day, we have alienated ownership of the property, or separated or transferred ownership. Does that make sense for everybody? So,
or the government takes it.
Or the government takes it. That could be an involuntary form of alienation. Or, a gift could be a voluntary form of alienation. So there are ways to do this voluntarily, and there are ways to be forced to do this against your will. And we're going to talk
Anthony mentioned owner's consent. I think that'd be a great way to tie that in there.
Yeah, right. Anthony's exactly right. Voluntary means that it's being done with the owner's consent. Involuntary means it's being done without their consent. I won't say against their wishes, but we didn't ask them, With an involuntary alienation, we don't know whether they want to or not because we don't care. We just do it anyway. That's what involuntary means. You don't get the choice. So we're going to talk about the different forms of alienation. That usually involves our favorite word here. And this is going to be our favorite word for this chapter, a deed. Deeds equal alienation. The only time we use deeds is if we are transferring ownership from a grantor to a grantee. By the way, we would also use a deed to change the form of ownership and have the same owners. You can't, in essence, wave a magic wand and say, oh, well, we used to be tenants in common and now we're going to be joint tenants. But could you sell it to yourself? Could the same owners who are tenants in common right now deed it over to themselves as joint tenants if they wanted to become joint tenants? Could they do that?
Yes.
Yes.
Exactly. So
to be registered.
anytime we want to transfer or change the type of ownership, we need a deed to do that. A deed is the document. Well, Isabella says re-recording the deed. I'm going to take out the prefix re, Isabella, because re-recording a deed accomplishes nothing. Once you've recorded it, it's recorded. And here's why I got to point that out, Isabella, because I'm glad you said that. There's not one deed. A property does not have one deed. See, when I see re-recording VD, that "the" scares the crap out of me because I know what's in your brain. You want the deed to be a title. It's not. Every time ownership is transferred, it's a brand new deed. It's a brand new day. It's a brand new transfer of ownership. A deed is a one-shot deal. It transfers ownership one time, and then it is a useless piece of paper from that point forward. It has no value except in that moment. Did everybody hear me on that? So every time we transfer ownership, there's going to be a new what?
New deed.
A new deed.
It's
So
a new deed.
when we go and record that deed, we're not re-recording the old deed. What we're recording is
A new deed.
a brand new one.
I have a question.
Okay?
I haven't got this far along, but we're in the process of buying some rentals, but we're doing financing straight through the owner. So when we do the deeds and everything, are they going to put special provisions on there to protect them, or is that going to be separately through the contract?
If you mean as far as the financing goes, if it's just owner financing, then nothing would be mentioned about that on the deed because financing doesn't go on the deed.
So that wouldn't have anything to do with, because they have no protection, obviously, through a mortgage company or anything.
Correct, right. That's all the part of the financing, which is a different thing than the deed. The ownership has nothing to do with how ownership is being financed. But the idea of ownership, the deed would not be impacted. Just like a deed is not impacted when you borrow money from a bank. And that's another thing we probably need to get out there. Hear me on this, folks. The bank does not own your house.
The mortgage company does.
The mortgage company does not own your house. You own your house.
But they have a lien against your house.
You were the one
Okay.
who showed up on the deed as the grantee. Unless you signed another deed transferring ownership to the lender, it doesn't belong to them. It belongs to you. They have a lien against the property.
If you
But
default.
that is not the same thing as ownership. Here's how you know your bank doesn't have ownership. Can they move in?
No.
No, then they don't own it. Who lives there?
You.
You
owner.
you do. You're the owner. You have ownership. You have title. And so financing and ownership don't go together. They're two separate topics, and they very often get jumbled together. I get that, and for good reason, because a lot of times people can't take ownership if they don't have financing. But they are separate ideas, and we're going to spend a lot of time talking about financing too. When we are doing a transfer of title, the owner is going to be called the grantor, as we talked about, and the recipient or buyer is going to be called the grantee. They like to throw this on a test. The only one who needs to sign the thing is the grantor. We don't care about the grantee when we're making a deed. The deed is all about the grantor. And here's why. Right now, we'll go back and pick on Carlene again. Carlene has made the claim that she owns her house. Is that right, Carlene?
Yes, sir.
If you wanted to sell your house, Carlene, you can't transfer ownership to somebody else without first saying, I don't own this anymore. You have to give up your claim in that property before you can give it over to somebody, before somebody else can make a claim. Does that make sense, Carlene?
Yep, it does.
Voluntary alienation.
So
Like
the
quitclaim
whole,
deed?
I'm sorry.
Like quitclaim deed?
So we're going to talk about the different types of deed. Hold that thought, okay? But any deed Any deed, first and foremost, says, I don't own this anymore. That's what you're saying on a deed.
Yeah.
Well, let me ask you a question. Who's going to make that statement? It's not the grantee. Who makes the statement of I don't own this anymore?
It's
The
the grantor.
It's
Voluntary
the
alienation.
grantor, and that's why it's only the grantor who signs the deed. Does that make sense?
Yes.
The
Yes.
grantor who is saying, I don't own this anymore. And they're going to go on to further say, and whatever ownership I have, I'm transferring over to, and then they're going to name the grantee. How does the grantee actually claim ownership?
They have
This is
to,
gonna show up on the test. How does the grantee claim ownership? It's not on the deed. How do they do it?
they have to file it.
They have to file what?
Courthouse.
File transfer of ownership, the deed.
They
Record
have
the deed.
File their
to
claim.
deed at the county courthouse. They take the deed to the county courthouse and say, I want you to put this in the public record so everybody knows this property is now what?
Mine.
Mine. That's the grantee making their claim. See, the grantor is giving up a claim. The grantee is going to make a claim, but they do that at the courthouse, not on a piece of paper. Is everybody with me on that?
Mm-hmm.
Okay. So the grantor is going to sign the deed. We have a law in North Carolina called the Statute of Fraud. Statute is a fancy word for law. It's all it means. Statute is just a law. So this is the law of frauds, the law of people who commit fraud. What do you think the number one best defense against somebody committing fraud is? Make them put everything in what?
Right.
In writing. And that's why this law is called the Statute of Frauds. Here's what, and this will show up on a test, and I will tell you it's one of the commonly missed things right here. This topic gets past people because you try to oversimplify it. There are plenty of things I'll say, keep it simple, right? KISS method, keep it simple. You can insert whatever word you want there at the end. I got the not politically correct version in high school, stupid. Right? Keep it simple, stupid. And I think they say keep it simple, sweetheart now, but whichever one you prefer, it works. Melissa will remember Linda Barnes saying kiss, baby, kiss, every day in science class. But the Statute of Frauds is a law in North Carolina that says certain, some, not all, some very selected documents will only have any legal weight if they are in what?
Writing.
Writing. That does not mean, now here's where I don't want you to oversimplify it. I did not say that documents have to be in writing.
They have to be recorded.
No, they don't have to be recorded either. I did not say either of those things. What I said is that some documents, if they are not in writing, are not worth anything in the one place we want documents to matter, which is where?
The court of law.
In a court of law. The Statute of Fraud says, don't complain to a court of law about these agreements unless you put the agreement into writing. That's what the Statute of Fraud says. Is everybody okay on that?
Yes.
Shauna's not okay on that. All right. So Shauna,
You said some documents are certain documents.
I said both, some or certain. In other words,
Okay.
it's a list of things, not all documents.
Not all. Okay.
Understand. See, here's the thing. We know, you may not know you know it, but you know it. You know that every document does not have to be in writing to be enforceable in a court of law. Here's how you know that. How many of you ever watched Judge Judy? How many times you watch Judge Judy and she asks them, do you have anything in writing? They go, mm-mm. And she still keeps talking to them, trying to figure out what the hell happened.
Yes, they had a verbal agreement.
Here's what I'm telling you. If she was dealing with things that were covered under this law, as soon as she heard it wasn't in writing, she would have to say, get out of my face. I don't care what happened. I can't take any action as a judge because this kind of agreement is not enforceable unless it is in writing. And not every agreement. So I'm going to give you an example of a document that's not covered by the statute of frauds in North Carolina. A lease. In North Carolina, a lease is not covered by the statute of frauds. Here's what that means. If you have a landlord and a tenant who don't have a written lease, and one of them sues the other, will a judge sit there and listen to that case?
Yes.
Yes.
Yes, they will, because that document does not have to be in writing for a judge to consider that case. Does that make sense for everybody? Everybody follow me on that? So the judge is going to sit there and listen to the he said, she said, and try to figure out who's telling the truth and who's telling the fib and all of that stuff because they can. That doesn't mean it's a good idea to have an oral lease. It just means it could be enforced. Let me give you another example of a document that is covered by the statute of frauds. A sales contract for real estate, a real estate purchase agreement is covered by the statute of frauds. So let me give you a hypothetical situation. Let's say that Jenny wants to purchase a property that belongs to TJ. And they go out and they come to an agreement, a handshake deal for Jenny to pay TJ $250,000 for the property. Does everybody follow me on this?
Yes.
They don't write it down because they trust each other. Now, this is a very legal agreement. The law does not say they have to put this in writing to go through with it. Can they go through with it with an oral agreement?
Yes, it just has to be in writing to go to court.
They can. So they don't put it in writing. TJ says, oh, we ain't gonna bother with all that mess. I trust you. They have a handshake deal. And then it comes time to close and Jenny refuses to close. Now, normally, how would you settle a dispute with somebody if they refuse to do something they promised to do? What's the legal way you would normally try to settle that dispute?
You sue them.
You would take them and go to court. So TJ's going to file that lawsuit, and they're going to end up in Wake County District Court. And the judge is going to say, okay, we are here today about what appears to be a real estate purchase agreement. Is that correct? And Jenny and TJ are going to say yes. And the judge is going to say, may I have a copy of the written purchase agreement? And TJ is going to say, well, we didn't put it in writing, but I tell you what I did. I recorded it on my cell phone. I got video here and audio, and I got 12 witnesses that saw us have this discussion. So we got plenty of proof that Jenny agreed to this. And Jenny speaks up and says, oh, you ain't got to show all that proof. I freely admit right here, I'm standing right here. I'll tell you the truth. I shook the man's hand. I told him I would buy it for $250, but I'm telling you, I'm not buying it now. What is the judge going to say?
Get out of my courtroom.
Yeah.
Get out of
Not in writing.
Because if you want me to enforce this agreement,
It had to be in writing.
put it in writing. Because a real estate sales contract in North Carolina can only be enforced if it is in writing. Does that make sense for everybody?
Yes.
So this law is basically just a list of documents that if you want a court to act on them, you better put them in writing.
Travis, Jessica had a quick question, and it was a little earlier, only if she was a judge in NC, right? And I think this was when you were talking about...
This is a national topic. The statute of frauds is a North Carolina law, but it's a law that's mirrored in every other state. So this law there's some tweaks minorly between state to state, but as far as the test goes, this is going to be all the same state to state to state. Okay?
And then
Do we
Ed and Danielle, sorry.
No, I'm saying, do we understand kind of what I'm saying here, though? Because I want to make sure this is one of those things that's easily confused for people. It just says that certain legal documents aren't enforceable, don't have any legal power unless they are in writing. And then, so if you go look at the statute of frauds, it's going to have a list of these things are covered. These things must be in writing if you want to enforce them. Okay?
So, Travis, so this is for the document that all needs to be in writing to be enforceable?
If the document is on the list of documents that are covered by the statute of frauds, then that document needs to be in writing in order to be enforceable.
Are we going to need to remember the other documents, or just remember that real estate transfer because we're doing real estate?
So the one that I harped on just now is the one that they're going to test you on most likely. Do you know that a real estate sales contract, in order to be enforceable, must be what?
In writing.
In writing, according to the statute of frauds.
So they may give examples of like on video, et cetera.
Right. They might try to run you down a rabbit hole saying, well, they had a video, they had audio recording, they had this, they had witnesses, they had testimony. That none of that matters if the document is covered by the statute of frauds, because the statute of frauds is very clear. It basically says you can't consider, testimony. You have to look at the written document, and if there's no written document, there's no case.
So this is just in North Carolina, correct?
No, this is national. This is national. It's the North Carolina statute of frauds, but every state has a version of this law.
Basically, if it's not in writing, it never happened.
As far as the courts are concerned, it never happened. It has no legal force. They could close it if they wanted to. They're always going to stop them from that. But there's no legal force. I mean, the whole reason you get somebody to sign a contract is you want to be able to have the right to take them to court if they don't act. Well, you're wasting your time if you don't put it in writing, if it's covered by the statute of frauds.
Basically, it's for the seller's protection, basically.
It's for protection, right? The only reason we have agreements is for when people don't do what they promised they were going to do. And so this is a protection.
Travis, I'm going to retell just to make sure. So all we need to remember for this is the real estate contract is under these statutes of frauds and
sales, real estate sales contract.
Sales contract, okay.
Because and I have to do this because this is one of the classic mistakes on a test, right, Angela? Is people think that transactions mean sales. They are two different things. Leases are also transactions. And what I'm telling you is a real estate contract would include leases and purchase agreements. And leases are not covered by the statute of frauds, but purchase agreements are covered by the statute of frauds. So I didn't want to interrupt you, but I want to make sure you, in your mind, you understand that a real estate sales contract is different than a real estate contract.
Okay, that's actually very important to remind me. So all we need to remember is a real estate sale contract is covered by this law, so it needs to be in written format. Otherwise, it's not enforceable, and that's what we need to remember. Okay,
You got it.
Got it. Thank you.
And we will add some other things to that list as we go through the class, but that's by far the most important one that they're likely to ask you about on the test.
Travis, can I ask a question?
Sure, Danielle.
So kind of in this day and age, just curious, are emails considered written?
That is a great question, and yes. Written does not mean on a fancy form drawn up by an attorney. Written could mean any form of written communication. So text, email, Facebook Messenger. As a matter of fact, there was actually a court case in Wilson County about 4 or 5 years ago now where a seller refused to sell the property and the buyer claimed we have a contract. And the seller said, we have no such contract. It was a farm in Wilson County. Guy was talking to some person and they offered to buy his farm and they agreed on a purchase price of $250,000 for the farm. And the buyer said, okay, I'll pay you $250,000 for it. And the buyer wrote the seller a deposit check for $10,000. And on the check, the buyer wrote on the memo line the address of the property being purchased, and said $240,000 balance remaining. So it was a $10,000 check, and they wrote the address on the memo line and $240,000 balance remaining. Well, the seller, here's what happened. After the seller started telling everybody he was selling his property, somebody said, you fool, man, you could have got double that from somebody. And so the seller tried to back out. And the buyer sued him. He said, no, we have a contract. And the seller thought he had this thing slam dunk won because he walked into court. Somebody told him if he didn't have a contract, they didn't have a contract in writing, he didn't have to follow it. Guess what the contract in writing the buyer produced was?
That check.
That canceled check.
Dang,
And
homie.
handed it to the judge and said, Your Honor, it identifies the property I was purchasing. It identifies the sales price of the property because you can add the balance remaining to the amount of the check. And I signed it. And guess who else signed it?
The seller.
The seller, when he did what?
Cashed it or deposited it.
Endorsed that check on the back and deposited in his bank. And a judge in Wilson County said, this is a sales contract and this is enforceable. So that's a great question, Danielle. It doesn't have to be some fancy document. Written just means written.
Could be on a napkin.
In lipstick on a cocktail napkin. Is that, you know, doesn't matter. Okay. Are we all good? Okay. That's the statute of frauds. Now, deeds must be in writing. They're another thing that's covered by the statute of frauds. I think that's relatively straightforward. You could not expect a court of law to enforce a deed that you said was verbal, right? If you walk into a court of law and say, no, I promise he said I own the property. They're like, no, you're going to have to come again with something stronger than that. So the deed is covered by the statute of frauds. It has to be in writing. The grantor has to have legal capacity. We're going to talk a lot about legal capacity when we get to contract law, but for right now, they need to be these three things. Not a minor. So in North Carolina, for contract purposes, that's 18 or older. Legally competent means they have not been declared mentally incompetent by a court of law. And sober. And so that eliminates about 80% of y'all by the time you make it to class at night, I know. So, you know, make sure that your grantor is, now, here's, all joking aside, this may show up as a test question. This is very much fair game for a test question. What if they give you a test question where they say the seller was drunk at the closing? Well, the seller's the grantor, correct? And in order to have a valid conveyance or transfer, this just means transfer, in order for that to be valid, the grantor must be all of those things. So if the grantor was drunk, would we have a valid conveyance?
No.
No.
No, we probably would not. So that's fair game for a test, test question, by the way. And it's got to identify the grantor and grantee, but it's going to be signed by the grantor. Okay. John said, so the buyer can be hammered. Yes, most likely, John. There is no requirement that the grantee be sober at a closing, just the grantor. The grantor is the one doing the heavy lifting. Now, that does not mean the grantee may not sign other legal documents that would create problems if they were intoxicated, especially like loan documents. Krista said, what about the realtor? Krista, I've never been sober at a closing. I'm kidding. I'm kidding.
I'm in champagne, right? But really fast, Travis. Okay, so if the grantor is the only one that legally must be of like sound mind, does that not apply to the buyer also, like under duress? I know we talk about that later. I don't know if this is the same thing.
When we get to contracts, because contracts are two-sided things, we look at both sides, seller and buyer. That's a great question. But because we're only talking about deeds, and deeds are very one-sided, it's just the grantor who has this responsibility. We're only focusing on them right now.
Okay.
And Mark said, if you're drunk when you get married, you're still married. Just say it. Yeah.
That makes me think of that movie. What is it? Hangover.
Oh, God. Y'all want to hear the funniest thing ever was I had actually my business partner hit me with the weirdest question of my life. Not this past Christmas, but the Christmas before, like the day before Christmas. He said, I really need to ask you something that's important. And I said, what is it? He said, will you marry me? And I said, huh? And he immediately goes, no. I mean, I'm getting married. Will you conduct the ceremony? That's what he meant. Like, I'm like, you better specify here because you had me like all twisted up for a couple of minutes. And then I looked at him and I said, wait a minute. I actually think the first question was more reasonable than the second one. You want me to conduct your me? Are you
Amen.
I had to get ordained to marry these people.
Oh,
isn't that crazy?
And Travis, in North Carolina, it's not, you're not legally married. If you get married by someone that's not a minister, they can be contested in court.
Right, exactly. That's why I had to get ordained to marry. And so then I made the same mistake like 2 months later. And they're like, well, what'd you do over Christmas break? I said, well, I married somebody. And they're like, oh, well, congratulations. I'm like, no. So we got to work on that whole terminology around that thing. I don't know how you express that in a better way. But.
I mean, you can't get ordained online. You have to actually be a minister. You have to actually be a minister in North Carolina.
I know it was a process.
You became a minister?
It was a process.
Wow. So you can marry people.
But
you're your one-stop shopping for trapping people.
Yeah, no kidding.
Right.
Exactly. You could marry my son and his
fiance. And look, and then they wanted me to not only want me to conduct the thing, they said, well, we don't want a traditional ceremony. I said, well, what do you want me to say? They said, well, we just thought you'd come up with something. I said, so you want me to conduct a wedding, first one ever, and you want me to write the whole ceremony too? Yeah, y'all must be insane. But they are insane. I'm not kidding. At the wedding, not at the reception, but at the actual wedding, there was a trapeze artist in a cage, hanging upside down, filling up people's champagne glasses as they went to their seats. Like she was hanging upside down in this thing, and she would take the champagne bottles out of these elevated ice things and pour your champagne while she was like dangling and that's the kind of wedding I officiate, apparently.
That's amazing.
Well, the more expensive the wedding, the more likely for divorce. So hopefully your business partner got a prenup.
I just said, listen, I'm just part of this circus. I am not the ringleader either. I'm just here.
I would make friends with the girl who was upside down.
How do you even get into that line of work? Good question. Good question. I'm the champagne pour acrobat. That's a very specific line of work. All right. So what else do we need about a deed? This right here will show up on the test. From the grantee's perspective, only one thing's important about the deed: getting it recorded. Not the grantor's perspective, but whose perspective?
Grantee.
This matters for the grantee. Not the grantor, but for the grantee. It is absolutely critical for the grantee that they record their deed because, as I said to Carlene earlier, that's how you make your claim on the property. Because here's what happens. When we go to a settlement meeting, we call them closings, but they really should be called settlement meetings. When we go to the closing attorney's office and we sit down at a settlement meeting, the seller signs the deed. Okay, so we have a piece of paper that says the seller has conveyed ownership to the buyer. Here's the problem with that. In the eyes of the rest of the world, who still owns the property at that moment?
The seller?
The seller does, because the legal documents that have been recorded at the county courthouse all have the seller's name on them. That one that was just signed at that settlement meeting, nobody knows it exists. Does that make sense for everybody? So as far as the world is concerned, the seller still owns the property. The grantor still owns the property. That is why it is so important for the grantee to immediately take that deed and do what with it?
Record it at the courthouse.
Take it to the county courthouse in the county where the property is located and record it so that you've made your claim. You've told the world this property now belongs to me. That's the idea of recordation. All right. That can be done online, In some counties, most counties, it still has to be done physically. Some counties do allow online recording of documents, but generally only the metro counties in North Carolina do. Most counties in North Carolina still require in-person recording. That's one of the reasons why when you go to particularly smaller counties, all of the closing attorneys' offices are in little houses that are right next door to the courthouse. And they're all like scattered right around the courthouse. So that way, when they do a quick closing, they don't have far to go to record the documents. But like, for example, Wake County does, electronic recording or has it available. Durham County does. I believe Orange County does now. That's a fairly recent development for Orange County though. But most counties are still in-person recording.
Julia, I think the answer to your question is yes, if you're asking about recording.
Yes, Julia is asking about recording, so the attorney does it. Yes, that's one of the very many reasons buyers usually handle or hire closing attorneys to handle their closing. Is the responsibility for recording the documents would then fall to the attorney to handle rather than the buyer or grantee having to go do it themselves. Every once in a while in your career, you may end up being the one to record the documents. I have been known to do that. I have left closings, that ran late in the day when it was 4:15 in the afternoon. And I looked at the attorney and I said, are you going to get that recorded today? Because we're in a county that requires in-person recording, which means somebody has to physically get to the courthouse to record that document. And the attorney says, no, we're going to do it tomorrow. See, I have a problem with that answer. Here's one problem I have with that answer. If I'm representing that buyer, my buyer doesn't actually own the property in the eyes of the world until that document has been recorded. So I don't want to wait an extra day because theoretically, we shouldn't be giving the buyer the keys to the property until that deed's been recorded. Does that make sense for everybody? Mm-hmm. They don't have insurance on that property until that deed's been recorded. Because imagine if the house caught on fire overnight and the buyer's insurance company got that claim. They'd be like, I'm not paying this claim. My client doesn't even own the house because the deed had not been recorded. So I don't like that delay. But I'm going to be real honest with you. I like y'all, so I'm going to be real honest with you. You know why I would not like that response if it was 4:15 in the afternoon and the closing attorney said, no, we're just going to record tomorrow. You know why mostly I would not like that response?
Because somebody else will go and record it before they do.
You don't get your... Somebody gave such a nice answer because I want to make sure I was looking out for my clients. So sweet. I don't get paid in most cases until that
you don't get paid.
Recorded. The closing attorneys don't release any funds, including commissions, until that deed is recorded. So if you look at me,
you're not done until the house is completely finished. I mean, just because you've signed the document.
4:15 in the afternoon, you say we don't have time to get to the courthouse. I'm like, hold my beer, watch me. We got time. And
so why do they? I'm sorry, Travis.
Yeah.
Why do they do closings on like Fridays or late evenings?
Well,
like you said, you can't get.
They shouldn't. They really shouldn't. I try not to schedule any past 1 o'clock in the afternoon for that very reason. Right. Sometimes you get delayed when documents aren't there from the lender on time. Everybody's just kind of sitting around waiting. I try to stay away from Friday closings like the plague for that very reason, because if you don't get recorded on a Friday, then that's the whole weekend that someone doesn't own the property. That's a problem. So I try to avoid those.
Hey, Travis, so in the real life operation, do the attorney really just record it and then make a trip to the courthouse and then, well, they may have like 4 closings in one day. They usually wait, right? They're not going to do that.
They make 2 trips a day, one at lunch and one in the afternoon.
So they do?
Yeah.
Okay.
But now imagine if they've done 6 closings that day, and 4 of them were in Orange County, 1 was in Durham County, and 1 was in Wake County. They got 3 courthouses they have to go to. That's a lot of running around.
Okay.
Yeah.
Because you can't go to any courthouse. You have to go to the one in the county where the property's located. Okay.
Hey, Travis, I'm sorry. Can you go back to the last slide real quick?
This one?
The one talking about, the one before, there you go, that one right there.
Okay.
Thank you, that's all.
Yep. The Connor Act is a law very similar to the Statute of Frauds because it deals with certain documents. Again, there's that same, so remember, it's just a list of documents. Remember Shauna asked me that question earlier? She said, did I say certain documents? And that's what I mean, there's just a list of documents. Well, when we were talking about the Statute of Frauds, we said certain documents had to be in writing to be enforceable. The Connor Act goes one step further than that and says certain documents are so important that they're not enforceable unless they are recorded in the county courthouse. And so I'm going to set up like two lists here so I can show you like how this might relate. So I'm going to put Statute of Frauds. And then I'm going to put Connor Act. Real estate sales contract. Did we say that was covered under the Statute of Frauds?
Yes.
Yes.
Okay, so I'm going to put RE sales contract. It is. It is not covered under the Connor Act. So if you were trying to give me what the legal requirements were for a real estate sales contract to be enforced in a court of law in North Carolina, you would say it has to be what?
In writing.
In writing, but it doesn't have to be
recorded.
Recorded. Does that make sense for everybody? Because it's covered by the Statute of Frauds, but it's not covered by the Connor Act. Whereas a deed is over here and over there. So a deed in North Carolina, in order to be enforceable in a court of law, must be both what?
In writing and recorded.
And recorded at the county courthouse. Does that make sense for everybody?
Yes.
Okay. So we're gonna get things to add to these lists, but it's not gonna be long. I mean, really, this covers most of it, honestly. But I want you to understand the differentiation between them. Like some things are only under the Statute of Frauds, and some things are under both the Statute of Frauds and the Connor Act. And here's how they're going to ask you this on the test. Does a real estate sales contract need to be recorded in the county courthouse in order to be enforceable in a court of law?
No.
No, it does not. Does a deed need to be recorded in the county courthouse to be enforceable in a court of law?
Yeah.
Yes.
No. Yes, it does. Okay, are we all good there? Good. Okay. All right. I want everybody to take a deep breath. Because we are about to enter into a realm that has confused roughly 98.7% of all students in the history of taking real estate classes. The different types of deeds. Before we go any further, I'm going to say this, and it might make a difference. My guess is it won't, but we'll see. See how good y'all are. It's nighttime. All deeds do the same thing. Say that out loud to yourself. All deeds do what?
The same thing.
The same thing. So a quitclaim deed does the same thing as a general warranty deed, does the same thing as a special warranty deed. Because all deeds transfer ownership. So if somebody asks you what a general warranty deed does, you say it what?
Transfers ownership.
Transfers ownership. If somebody says to you, what does a quitclaim deed do? What do you say?
Transfers ownership.
Transfers ownership. So here's the relevant question then. And since this is a pyramid, we'll say the $25,000 question. Here is the big question. Why the hell are there so many types if they all do the same thing? And it's a
Depends on the
fair
financial
question.
thing. It depends on the financial situation with it, or no?
It depends
Well,
on the use of the property. Like if you,
it doesn't depend on the use of the property. The financial situation, that's sort of you may be getting around to it, maybe, but I think it might.
About liens?
Well, it could be related to liens.
It also could depend on if more than one person owns the property.
Could depend on more than one person owns the property, but
The granting
Is there a difference
process.
in what they're transferring?
you're all hunting and nobody.
I'm transferring the deed, but I'm still financially liable for anything on it. Maybe.
That's
Like,
okay, Mark. I like that statement. Mark said, "I've transferred title, but I still have some financial liability with some of these things." That I can deal with, Mark. And I'm gonna refine that down, but at least that's you're in the right zip code there. Okay.
Not all the different deeds. The general warranty deed guarantee is the best one you can have. Like
Go back. You said the word I wanted to hear. Wait, say that G word again.
the general warranty deed is the best one you can have. It guarantees everything.
Right
The
there.
rest of them have
Right there. There's the word. What was the word?
general.
Guarantee.
Guaranteed.
The only difference between these deeds, some of them come with a guarantee, and some don't. That's going to be the difference between them. Now, let me ask you a question before we go any further. In a transaction, who would be making a guarantee that things would be right after the transaction was over? Would that generally be the buyer, the purchaser, or would that be the seller?
The grantor.
Who would be making a guarantee that things were going to stay okay down the road?
the buyer.
Grantor.
Seller. Yeah.
It's the buyer.
The buyer? So let me ask you this, Kenny.
It depends on which deed we're talking about.
When you go to Best Buy and they ask you if you want to purchase a warranty with that, it would be you that was guaranteeing the TV wasn't going to break, or would it be Best Buy that be guaranteeing the TV wouldn't break?
Okay, with Best Buy seller.
Is Best Buy the seller or the buyer?
The seller.
Seller. When you buy a car and you get a warranty, a guarantee, does that warranty come from the buyer or does it come from the seller? When you buy a car, does warranty come from the buyer or does it come from the seller?
Seller.
Guarantee come from, think about who says it. Think about the conversation. I guarantee it. I guarantee you ain't gonna have no problems. Who says that? It's not the buyer who says that. It's the seller.
The seller doesn't want your money.
The only difference between these different types of deeds is there a guarantee from the grantor or not? And if there is one, how strong of one there is. Is everybody with me on that?
Okay.
What we got is some deeds that come with a really strong guarantor or guarantee from the grantor. That's how you combine two words. A really strong guarantee from the grantor. You have some deeds that come with a wishy-washy guarantee from the grantor. And you have some deeds that come with no guarantee whatsoever from the grantor.
Nice.
And that's what we need to differentiate. But I'm going to say it one more time before we go any further forward and before you tangle yourself up mentally on these rocks. All deeds do the same thing. They all transfer ownership. That's what a deed is for. Is everybody with me? You okay?
Yes.
So,
quick question, Travis.
Yep.
So like an as-is sale, would that be considered a bargain and sale deed?
As-is sale has nothing to do with it because it's a great question. What we're guaranteeing is not the condition of the property. What we're guaranteeing is the condition of the title.
The title, okay.
As-is sales usually refer to the status of the property. Like we're not guaranteeing that the roof doesn't need replacing. You know, that's a different type of a guarantee. You can get those kind of guarantees too. But with deeds, what would be guaranteed is the status of the title.
Okay.
Whether or not I'm transferring you good title. Because remember, Carlene said she was very confident she owned her property because there's 8 billion of us on this planet and only one who's claimed ownership. And by the way, when she bought the property, she bought it from the only one out of 8 billion who was claiming ownership at that point in time. Would she have been a little bit more nervous if there had been 2 people claiming ownership at that point in time? Would she have been less likely to want to pay one of them? Would she have said, no, y'all got to figure this out before, I'm not paying nobody until we figure out which one of you actually owns it? That's a fair statement, isn't it? Right? So, with that in mind, I just want to remind you, there is no such thing as a better deed or a best deed at transferring ownership. They all do that exactly the same. There is a better or best deed, though, from the perspective of this person. This matters to the grantee because the grantor is the one doing something in the deed. The grantor is the one who would be making a guarantee. Let me ask you just a generic sort of question. In general, if you're selling something, would you rather sell it having to guarantee it in the future, or would you rather just be done with it, wash your hands of it, and you're on your own? Don't call me if you have a problem. In general, when you're selling something, which one would you rather have if you're the seller?
Rather be done with it.
Be done with it and have no future worries about it, right? Most sellers would. Sometimes sellers, though, have to put a guarantee on something to get it sold. So let me ask you a more in-depth real estate question then. If the seller would prefer a deed where they didn't have to make any guarantees, what kind of deed would the grantee like to get? One that what?
Guaranteed.
That does have guarantees. Does that make sense for everybody?
Yes.
So when I hear people say, "Oh, that's the best deed you can have," if you're the grantee, if you're the grantor, it's the worst kind of deed you can sign. Does that make sense? Because whatever, in this case, whatever is good for the grantee is going to be bad for the grantor, because it's the grantor who's making these guarantees. Is everybody with me so far? Okay. So let's talk about the one that in the eyes of the grantee is the best. It says this one provides the greatest protection for a purchaser or a grantee. Another way you could say that, it provides the most liability for who? If it has the greatest protection for the grantee, who's that the most liability for?
The grantor.
The grantor. Here's what a general warranty deed, and by the way, these are by far the most common deeds used in sales transactions, even though grantors hate these deeds. Well, if the deed is the grantor's thing, but they hate this one, why do you think this one is the most commonly used? Do you think buyers might, in their sales contract, ask for a particular type of deed if there are ones that are better for them? Do you think the buyer might put in the sales contract, I want this type of deed, I want a general warranty deed? Is that possible?
Yep.
And that's exactly what happens. Most sales contracts will specify that the seller or grantor must provide a general warranty deed. This is the bumper-to-bumper warranty on a new car, except we're not warranting the condition of the property. What we're warranting is the title. The guarantee that is coming from the grantor to the grantee here is pretty straightforward. I own it. I guarantee you I own it, which is also another way of saying I guarantee you that nobody else owns it. Does that make sense? That's the first guarantee a grantor is making in a general warranty deed. I own this property. First statement, it's mine. And the second statement, I have the right to sell it. Nobody else has the right to sell it because it's mine and I have the right to sell it. As a grantee, would those be would that be something you would want to hear from the person you were paying for the property? Would that make you feel a little bit better, at least, that the person was willing to guarantee on a legal document that they own this? Remember, you got to give them a lot of money. Would it make you feel better to hear them say, I guarantee you I own this property and I have the right to sell it? Would that make you feel a little bit better?
Yeah.
About what you were about to do?
Yeah.
The next part is really important. It says, I guarantee you there are no liens. Who was it that said liens? I think it was Jenny, right? Jenny said liens. I guarantee you there are no liens, there are no covenants, there are no restrictions, there are no encroachments, there are no easements, there are nothing that would limit your use of this property other than the ones I'm telling you about on this deed right here. I guarantee you that if those things exist, they're already on here. You're not going to be surprised by any of these things popping up later on. There's no liens coming down the road. There's no easements that we didn't tell you about. There's no covenants that we didn't tell you they were in existence. Is everybody okay with that?
I have a question about that.
Go for it.
So, just from like an example, so our house sold like 4 times and nobody ever knew it was in the HOA, and so it's never been enforced on our house for 20 years. So the owners didn't know about it, so they didn't disclose it, but would they still be responsible even though they didn't know about it? So it's not that it doesn't matter if they knew or not.
Correct.
Okay.
Because what they're guaranteeing is that they don't exist. They're saying everything you need to know, we've told you. So technically speaking, if they signed a general warranty deed, they are liable for that, and they could be sued.
But they didn't know, though. So you said
even if they didn't know, because they're not saying, I'm telling you the ones I know about. They're saying, I guarantee there are none. That's the weight of this thing.
So ignorance is not an excuse.
I'm sorry?
I said ignorance is not an excuse.
Right, it's exactly right. Ignorance is not an excuse in this case.
Travis, so we see guarantee, but we still need receipts too, right?
Well, that's exactly right. I mean, just because somebody gives you a guarantee doesn't mean you just blindly trust them. That's a different thing. But this does give some legal teeth to a buyer who might want to come back down the road and sue a seller who conveyed something other than what they promised. Does that make sense, Dave?
Yes, sir.
Okay, so this is a guarantee that I'm selling you exactly what I promised to sell you. You know what you're buying. There's nothing hidden here. There's no man behind a curtain here. Okay, and so that's the second guarantee. So you got 1, 2 so far. Number 3 says, if anybody ever challenges your ownership, if somebody shows up and says, no, I think this property belonged to my great-grandma, I think you should get out. This property belonged to my great-grandma, and therefore it should be my property. If that were to happen, the grantor is saying, no matter how long ago, or no matter how far in the future, if some fool shows up here and tries to claim to you that they own it, that's a lie. And I will defend you. You won't even have to worry about going to court and defending against that fool. I will do it for you. I feel so strongly that I own this property and I am the rightful owner of this property that I guarantee you'll never have to deal with anybody challenging your ownership. Is everybody okay on that guarantee?
Yes.
And here's the big one. And this is what differentiates a general warranty deed from every other type of deed. These things that I said I guarantee, how long is that warranty going to last?
Forever.
Forever.
Forever. This is a warranty that never expires. So technically speaking, Bev, when in your case right there, not only could the grantors who sold you the property be held liable, so could the grantors who sold them the property, so could the grantors who sold them the property, because they all are on, if they signed a general warranty deed, they are all on the hook all the way back to the beginning of time and all the way forward into the future.
The one that sold them was an attorney and he knew about it and he didn't disclose it to them.
Then he is absolutely on the hook. If he signed a general warranty deed, that's going to be key. Because that's
we're
what
going after the closing attorney more so because he also didn't discover it.
There you go. So, are y'all understanding me on these guarantees?
Yes.
Do you see why, if you were a buyer, this would be the one that would make you feel the safest about what you were buying?
Yes.
This would be the one where you would go, I got a pretty good idea that I'm buying what I think I'm buying, and I'm not worried, because if I ever have a problem, who's going to be on the hook for fixing my problem as far as title goes?
The previous owner.
Previous owner, the person, the grantor, the one who's giving me ownership right now. Ben said, what would they be liable for? What kind of damages? Financial? Yeah, that's exactly right, Ben. So if, for example, let's say Seth sells me a property and signs a general warranty deed, and then 20 years down the road, somebody pops up and challenges my claim of ownership. And I end up in court with this person, and it costs me $50,000 to deal with this issue in court costs. It would be Seth who would be on the hook for that $50,000 in court costs, because he guaranteed me I would never have that problem. Does that make sense, Ben?
Question, Travis. So if the previous grantor passed away, would it be their heirs that would be held responsible?
Heirs, absolutely. This is a warranty forever. It's not just the grantor, it's their heirs and assigns, and it goes on and on and on. Now, from a practical standpoint, could it be hard to track them down to sue them? Yes, absolutely. And we're going to talk about, you know, what you do to protect against that later on. But just right now, I want you to understand the basic guarantees that are being made. Okay.
So real quick, it kind of pertaining, without going into Beth's specific example, because I don't want her to have to disclose anything, but if in a scenario where there's no, like, she's not, you know, in the one you gave, Seth would be on the hook for the legal coverage, but in the instance where someone's not in the homeowners association, but they find out that they are being enforced in the homeowners association, is it just whatever damages they feel they're owed because of now that they have to put themselves in that?
It would be up to a judge, because what they could do is sue them for, okay, there's been real monetary damages. I had to pay court costs. I had to deal with all that. But then they could also sue for what's called consequential damages, which is, you know, this property's worth $50,000 less to me because I would have never bought it if I had known it was an HOA. So they could be, I mean, it could be all kinds of financial damages associated.
That's exactly what we're doing, because that's the only reason we bought the house, because there's no HOA.
So there you go, because it was one of your reasons for purchasing. Are we good on these guarantees? And does everybody see why, as a buyer, you would want this kind of deed? So right now, you just learned something about real estate. If you're a buyer, next time you sign a purchase agreement to purchase real estate, are you going to look for a paragraph somewhere that says the seller is going to convey you ownership via a general warranty deed? Is that going to be a statement you're going to want to make sure is in that purchase agreement?
Yes.
You better. You better.
How does it work with heirs when you were saying earlier? So if my parents signed one of these and then passed away, and someone later challenged it, they can come after me?
They sure can.
How? Oh, wow.
They sure can. That's the way the law is structured. And I'll tell you why the law is structured that way, Melissa. Because these deeds are very old legal documents, in the sense that this is English common law. This is like 1600s law. And back then, there was no such thing as like title insurance to make people whole. There was no such, you know, none of that existed. And so the only way that people could be made whole was to go after people in court. And you wanted the ability to go after, you know, generations later. And so that they did. For practical purposes now, we're going to talk about the solution now that's better than these guarantees. You want these guarantees, but you're going to probably also want to purchase insurance as well. And so we're going to talk about that a little while later. But for right now, I just want to make sure everybody understands the guarantee part of it. I will tell you, most important thing on the slide is that last bullet point that I have circled right there. That is the thing that makes a general warranty deed so much stronger from the grantee's perspective than any other type of deed. The fact that the guarantee is forever. It has no time limitation associated with it. Is everybody all right with that? Okay, good, good. So if we've done the one that's the absolute best from the grantee's perspective, there's nowhere to go from the grantee's perspective but down. And by the way, we'll back up a slide here. If this is the best from the grantee's perspective, where does this deed rank from the grantor's perspective?
First.
I don't want to sign this if I'm a grantor. I don't want to guarantee something forever. But if you're willing to pay me more money for my property because you're getting this kind of a deed, probably. Because here's what most sellers look at. What are the odds? What are the odds that somebody's actually going to have a title problem or somebody's going to have an unknown HOA pop up? Very rare. So they sign them. Maybe they shouldn't, but they do. They do. This is by far the most commonly used one. This next one, yeah, go ahead, Mark.
If I sell a house based on a previous owner, like I bought a house from somebody, then I sold it to somebody else. Apparently, I got the general warranty deed from the previous owner.
Sure.
How does that work? Do I have to
How does
ask
it work?
again?
The deed you got has nothing to do with the deed you're going to give to the person that's buying it from you. Every deed is a new deed. So you get to decide what you want to guarantee. If you want to give a general warranty deed, you give a general warranty deed. If you want to give less than a general warranty deed, then that's what you want to do. But every deed is a new process. So the kind you give to your purchaser has nothing to do with the one you received because it's you making the guarantee.
Exactly. So if somebody sue me, I can take it back and sue the previous.
You might be able to go back and sue the previous one who gave you the guarantee as well. But you know that'd be a fight you'd have to have with them, right? It daisy chain back from there. Okay. Next one, the special warranty deed or limited warranty deed. They both mean the same thing. Whenever you hear a limited warranty, you kind of cringe, right? Oh, it has a limited warranty. What does limited mean?
It's not a full warranty.
It's not a full
partial
warranty. It's very restricted. They try to get out of paying, right? Isn't that what limited means in most cases?
It's not unlimited.
Now, remember who's making these guarantees?
The grantor.
The grantor. So this is a grantor who's not willing to go as far as a general warranty deed. They're not willing to guarantee all of those things. So I'm going to go back to the general warranty deed and we're going to compare guarantee for guarantee. Look at the first one up here. We're going to look at number one up here first. Let me change pen color so I can point it out. Number one, here is the first guarantee. I own it and I have the right to sell it. Here's the first guarantee under a special warranty deed. Read that. I think I own it. I think it's mine. I got a document that says it's mine. I got a deed somewhere around here. It's got my name on it. So I'm pretty sure I own it. Let me ask you a question. You're the grantee. Which statement do you feel more comfortable with? Somebody saying, I absolutely guarantee you that I own this property and I have the right to sell it. Or a seller who's saying, I think it's mine. Pretty sure. Got documents that say it's mine. Which one would you be more comfortable with if you're the purchaser?
The first one.
The first one, right? Big time.
Especially for hundreds of thousands of dollars.
Big purchases. That's exactly right. A lot of money involved here. Oh, it gets worse. It gets worse. It says here, I guarantee you there's no encumbrances that I haven't told you about. There's no easements. There's no HOA that I didn't tell you about. There's no liens I didn't tell you about. I guarantee you that. Here's what the second guarantee is on a limited warranty deed. I guarantee you it was not encumbered while I owned it. I haven't done anything to encumber the property. There was no HOA formed while I owned the property. Is that different than saying there's no HOA, there's no covenants? Because over here you're saying, I guarantee you there's no covenants. There's none. They don't exist. Here's what they're saying is, well, I guarantee you they didn't come into existence while I owned the property. Let me ask you a question. What period of time does that leave wide open for speculation? When could the covenants have come into existence?
Before they
Before you owned it?
Before this person owned it. And guess what they're guaranteeing about before they owned it?
Nothing.
Nothing before I owned it. I only am willing to guarantee that no problems came into existence on the title to this property while I owned it. So from the day I bought it until the day I'm selling it to you, there's no liens I didn't tell you about. There's no covenants that came into existence during that time. There's no easements. So could a seller get away without even telling you about easements by signing the general warranty deed? Could a grantor get away without telling you about the easements?
Yeah, because the easement could have come into play.
Yes, they
before.
could.
Right. If the easements were there before they owned the property, they don't have to say jack about them because they're only guaranteeing you stuff that actually started while
Whenever
they
they
owned
purchased
the
it.
property.
Said for general, did you mean special?
For a special warranty. For a special warranty. For a general warranty, if I did, I apologize. For a general warranty, they can't get away with anything, right? On a general warranty, they're guaranteeing all the way back to the beginning of time, even if they didn't know. But here, they're saying, not while I owned it.
Hey, Travis, do you know of any examples of like when this would be used? Or like who would sign for this type of
So
deed?
what type of grantors like to use these deeds? Is that what you're asking?
Mm-hmm.
Well, let me throw this out there and see if y'all can think of it. I'm thinking of, let's say I bought the property at a special type of an auction. And
I did that.
The property was being auctioned because the previous owner didn't pay their bills. And so the property had been foreclosed on. So I didn't really buy it from the previous owner. I bought it at a foreclosure auction. Do you think I'm likely to get a deed that guarantees title problems all the way back to the beginning of time? Or am I more likely to get a deed just from the time that the whoever's selling me the property owned the property?
Yeah, a
the
special
time
warranty.
whoever
They don't know the
sells-
history.
I'm more likely to get a special warranty because they don't know the history. If I'm buying this thing from Bank of America, who bought it at a foreclosure auction, Bank of America is not going to put themselves on the hook forever. They're going to say, in all these 2 weeks that we've owned the property, nothing's happened. And they're going to give you a special warranty deed.
And the same apply for any liens on the property as well, correct?
Any liens. So what they would be guaranteeing is there's been no liens that came into existence since we bought it at the foreclosure auction. But any that might have been there before that, you own your own about that. So let me ask you this question. Would it be necessary to really research a little bit harder about the history of the property and any deeds and any covenants and any restrictions if you were getting a special warranty deed versus a general warranty deed?
Most definitely.
Would you feel like you needed to do a little bit more homework?
Oh, yes.
Mhm. Probably so. Probably so.
Hey, Travis, I got a question for you.
Yep.
So I bought a property in the mountains. It was a auction, but it was because the mother was in a nursing home. We had to sell the property, you know, because she still owned it. And so I got it as is. And so I didn't know when I bought it that I shared the well with the people in front of me. It was a whole, they owned both the lands, both places at one time. They sold the one in front of me. Now I've got 25 acres, but I wonder if I got a specialty warranty deed. I don't remember. It's been, but it was a auction.
On the top of it, it literally on the top, on the banner on the top, it'll say North Carolina General Warranty Deed or North Carolina Limited Warranty Deed.
Yeah, I need to go look.
Yeah. Okay, is everybody okay so far? Yep. Now it does, since you feel like flip or flop is all a lie now, you know, Ben, reality TV is real, my friend. I mean, take it from somebody who's been there and done that. It is so real.
Yeah, it's real. I've seen an episode of Flip or Flop where
By the way, our season premieres tonight. I saw that this morning. I'm like, oh,
yeah, I have it on DVR.
down home now. I don't. So that thing could pop out any week. I'm waiting for that email from HGTV to say, by the way, you're gonna be on television this week. Ugh. It's not coming for a while. It's going to be Thanksgiving week, most likely. I think it's going to be the season finale. But I did see the commercial this morning. I'm like, ugh, here it comes. Tonight.
So your house is season finale good?
I think it's going to be used as a season finale. So we were one of the last episodes.
It must have did a really good job.
Well, we were last in the hopper. You know, we were just in that, and they plan it out based on, you know, what they think the renovations are going to be and all that stuff. So I'm sure that has something to do with the timing, but we will not be one of these first few episodes in the season, that's for sure.
And Flip or Flop is real because I saw an episode where they purchased the house, and after they purchased it, they were working on it and they had to stop work because there was a lien that was on the house that they had to pay it off before they could continue doing anything to the house.
Yeah, I mean, it's all, you know, some of it is, and it's embellished, and, you know, it's television. It's television. You know, it's always
They have to
truth.
let some of it slide through to.
That's right. That's exactly right. Okay. Are we good on the difference between general warranty deed and a special warranty deed?
Hey, Travis, I have a question.
Yep.
If you're buying a house, how can a homeowner or real estate agent find the covenants that pertain to that property?
Well, most likely place is to go to the county courthouse because covenants are one of those things that's covered under the Connor Act, that covenants are not enforceable unless they have been recorded at the county courthouse. They are not always super easy to find, even if they've been recorded, though, depending on how they were indexed. So there's an art to researching them sometimes.
If anybody's wondering about that circumstance I was telling you about, ours were recorded on the deed. A lot of lawyers, when they see the previous title that was clear, they assume that's clear and they don't do the work, and he didn't do the work. It was always recorded. They somehow never enforced it on 8 of our homes. Nobody in the neighborhood ever knew. They confirmed with the HOA company that our house was not a part of it. Literally everybody known to man confirmed we weren't a part of it.
Yeah.
So
that's all tacking on. It happens a lot.
So Travis, in her instance, would that have been on the plat map?
Could have been. Sometimes covenants are, sometimes they're not, but they would be usually recorded as a separate document because usually covenants are very long, you know, so they're usually recorded as a whole separate document. But there should and would be reference usually to them on deeds. You know, each deed should refer to them because we're not, like, even in a general warranty deed, we're not saying we guarantee there are no covenants. We're saying that we guarantee there are none that we're not telling you about. That's what we're, you know, like, so this is where you would list them and say, you know, the covenants are found here. So, okay, everybody good on different? Big difference here is timing. General warranty makes these guarantees for how long? What period of time?
Forever.
Forever. Special warranty only warrants or guarantees
from the time of ownership.
During the grantor's time of ownership. Is everybody okay with that? But wait, there's more. We still haven't gotten to the bottom of the barrel from the grantee's perspective. Now, from the grantor's perspective, this is the best document ever created from a grantor's perspective because it doesn't put them on the hook for anything. But from a grantee's perspective, Well, I'm gonna ask y'all a hypothetical question. Who here would like to own the Biltmore estate in Asheville, North Carolina?
Me, I'm going there tomorrow.
Susie, you going there tomorrow? Well,
Yeah.
why don't you go as the owner? If you're gonna go, why don't you go in style? You can go as the owner.
I did that one time when I walked in and I said, oh, don't welcome me. I used to live here.
Yeah. Well, no, I mean, I'm telling you, I'll deed it over to you tonight, and you can take it and record that deed first thing in the morning. So when you go, you'll be the rightful owner of the property. You want me to do that?
How much does it?
Because it won't happen.
Why won't it happen?
No.
Seriously, if you get the deed, if you get a quitclaim deed drafted up tonight, conveying ownership of the Biltmore estate from me to you, I'll be glad to sign it. We'll get it notarized. No problem.
You gotta be the owner of the Biltmore, though.
Say that again.
You gotta be the owner of the Biltmore.
Y'all hear what she said, right?
Right.
That deed is worthless unless I'm the what?
The owner, the grantor.
Unless I'm the owner of the Biltmore. So somebody said, well, that's fraud. You can't do that. That's fraud. No, it's not. It's not fraud at all. Because here's what a quitclaim deed actually says. It actually says, I'm conveying any ownership I have,
if any.
if there is any. Actually, what a quitclaim deed says in plain terms, I have no idea if this property's mine. Don't know, don't care. But on the off chance that it is mine, I'm conveying whatever ownership I have to you, Susie. And I will be glad, Susie, if you will draft that quitclaim deed to sign it for you and get it notarized and back to you tomorrow so that you can take it to the Buncombe County Courthouse and record it. And they'll even record it for you if you pay them the fee. And you can walk around with a deed that says you own the Biltmore estate. And then you'll get arrested.
That's true.
Because you won't actually own the Biltmore estate. And it'll be it'll be a sad day for you to find out that your grantor conveyed to you exactly what they promised they would convey to you. Any ownership he had.
If
Except
any.
how much ownership does he have?
It doesn't have any.
None. So I would convey to you nothing.
How can that be legal?
What do you mean, how could it be illegal? How could it be legal?
How come there aren't stipulations in place? There's laws for everything. Why is there no law that says you cannot sell something that you cannot show that you own? Even with a special warranty deed, I believe I own it. I have documentation that says, hey, yeah, I probably own this. How can something like this even exist?
The key word you just said is sell. He didn't say sell
question.
it. He said transfer ownership.
It's a great question. And the truth is, I think she froze. I hope she can hear me. Can y'all hear me?
I can hear you.
The key question here is, why would we use such a deed? When is it appropriate to use such a deed? Even though these deeds would work in any situation, they are very rarely used in a sale for exactly the reason you just pointed out. Any buyer would be crazy to accept this kind of a deed. Most buyers are going to say, no way, I'm not paying you for the property if you're going to give me a quitclaim deed. I want a general warranty deed. But there are transactions which don't involve money.
Right.
And when the transactions don't involve money, the grantee doesn't have much leverage to demand a certain type of deed.
Right.
So let me give you an example. Let's say a married couple is in the process of getting divorced, and they get a divorce decree, and they own a home together. And the divorce decree grants ownership to the husband, full 100% ownership of the property to the husband. How much is he paying his now ex-wife for that?
Nothing.
Zero. He can't force her to sign any kind of a deed against her will. The court just said she had to transfer ownership. Right. Will a quitclaim deed transfer ownership?
Yes, it will.
Yes.
It will. So she's got the choice now. She can sign any kind of deed she wants. Is she likely to give her spouse one that where she guarantees, and if he ever has any problem, he can come back after her? Or is she
No.
likely to give him the one that has no guarantees whatsoever and say, get out of my face and leave me alone?
Severing all ties, one with no guarantee.
Does that make sense, Melissa?
Yeah, it does. In that situation, I could definitely see where that could be useful.
Yes.
So that you can walk
And
away.
I'll go you one further. There are times when there legitimately are questions about who owns the property. When, let's say that Kelly has a property she wants to sell and she inherited it from her long lost aunt that passed away. And she put the property on the market because she doesn't want it. And we'll say that Justice has gone under contract to buy it from Kelly. You follow, everybody following me so far? So Kelly's got this property she inherited. Now, did she likely get any guarantees from when she got ownership? Probably not, right? Because the person was dead. She didn't get any guarantees. So she's got ownership of the property. She wants to transfer it to Justice. Got a sales contract. And she's decided she's going to give Justice a general warranty deed because she can. She can give any kind of deed she wants to. Here's the problem, though. Justice doesn't trust Kelly, and so she starts researching the title anyway. And here's what Justice finds. That aunt that passed away, that left the property to Kelly, that lady's married. That lady is married to a young man, and he's still alive. Now, do we have a question right away of whether or not that young man might have some ownership of that property? If this,
no, he owns it.
Well, I mean, what I'm saying is, might he own it?
Yes, he might.
Yes. Yes. Kelly feels like she owns it, and she's the one that has the right to sell it. She's even got deed and everything that's got her name on it. And maybe this young man doesn't even know about the property. But is Justice going to be very worried about that? Because if Justice buys the property from Kelly and this young man shows up 20 years down the road, it's going to be Justice who's going to have the problem with trying to fight off this person. Does everybody follow me on that?
Yes.
So Justice might say to Kelly, you got to get this fixed. The best way for Kelly to fix this is to convince that young man to sign a quitclaim deed over to her. Because he would simply be what? Quitting his claim in the property. He wouldn't be saying he does own it. He would be saying, I don't know. But if I do, I don't anymore.
So, Travis,
Go ahead, Denisha.
so is this similar to having a quitclaim deed when you're trying to buy property and you're still married? And you're trying to get a new property and not have your spouse own the property that you're trying to purchase?
So you're saying you're purchasing property as a married couple, but you don't want your spouse to be an owner of that property?
No. So you're going through a divorce and you're trying to go ahead and purchase another home.
While you're still married.
Well, okay. While you're still married, the divorce hasn't been finalized.
Right. You're still married.
Yeah.
Right.
Okay.
I just want to be clear about that.
Okay, so the realtor is saying in order for your spouse not to have claim to the new property,
You need a free trade agreement.
a free trade agreement, not a quitclaim deed.
One is before the purchase, the other is after. If you bought the property and you didn't have a free trade agreement, you would need the spouse to then sign a quitclaim deed. Otherwise, they would have ownership. So one prevents the other.
So the one that you should do before is the transfer, you're saying?
No, the one you do before is the free trader agreement, because the free trader agreement prevents the other spouse from ever having ownership.
And
If you purchase it without the free trade agreement, they have ownership, and there's no guarantee they'll give that up for free.
And the free trade agreement is done before anything is done closing the home at the end of the.
Correct.
Thank you.
Denisha, I did that, and my ex-husband signed a free trade or signed that document, so he wouldn't have any claim
Yeah.
on my home, even though we were just separated, so technically still married.
Mhm.
So he signed that, so he wouldn't have any ownership over my new home.
Okay.
Yeah.
So this would be used anytime we are basically conveying ownership, either questionable ownership, we just don't know, or when we are conveying ownership with no money being exchanged. That's when these are most likely used. So let me give you an example of how quitclaim deeds might be used. Let's say that Jenny gets a knock on her door one day. And she opens the door up, and there's two attorneys standing out there. And they introduce themselves, and they represent the Investors Title Insurance Company. It's a title insurance company. And they explain to Jenny that they represent a seller in Indiana. Jenny, you ever been to Indiana? No? Okay.
No.
They represent a property seller in Indiana. And through some research being done by the buyer of that property, it has come to the attention of the authorities in Indiana that your great-grandmother was one of 12 children who inherited a property in Indiana back in 1968. And the property was sold by those 12 children in 1972, except only 11 of them signed that deed in 1972. The one that was missing, Jenny, is your great-grandmother. You following me, Jenny?
Yeah.
Now, Jenny, here's the thing. It is our contention at Investors Title Insurance Company that you don't actually have any ownership of this property. My guess is, since you've never been to Indiana and you never knew anything about this property and you never bothered to claim you own this property, is that you have no ownership at all of this property. And that's what we intend to prove in court, Jenny. If it comes to that, we intend to prove that in court. But Jenny, we don't want to do that. That's just nasty, and nobody needs to go down that route. Here's the thing, Jenny. Best case scenario, you own 1/12 of this property located in Indiana. Now, if you feel like you have sufficient documentation, now keep in mind, this property she's never heard of, right? What documentation is she gonna have?
None.
None. Now, Jenny, if you feel you have significant documentation to prove your 1/12 ownership, you might be entitled to 1/12 of the purchase price, and the property is being sold for $600,000, which means you would be entitled to $50,000 if you were able to prove your 1/12 ownership. Now, see, right about then, she starts seeing dollar signs flash in her eyes, right? Everybody with me? Jenny is excited at the prospect. But Jenny, here's our position, again, in case it wasn't clear the first time. You don't own this property, Jenny. Be honest. You didn't know this property existed. You probably don't even know who your great-grandmother in Indiana was, Jenny. And you certainly don't know that you might have inherited a 1/12 ownership from her. And you certainly don't have documents that have any kind of a proof whatsoever that you might own this property. So we're going to make this offer one time and one time only, Jenny. We have a check here with your name on it for $1,000. We also have a quitclaim deed. If you accept $1,000, you'll sign this quitclaim deed saying that you have no ownership of this property whatsoever and no claim against this property whatsoever. If you do not accept this $1,000, Jenny, we will file a lawsuit against you tomorrow. We anticipate your legal costs will be in excess of $100,000. We have filed 25,000 of these cases in the last 2 years, and we have never lost one. We will be back in an hour for your decision, Jenny. That's called curing a cloud on the title. Because Jenny's a cloud. She's a question mark. That seller in Indiana can't sell because Jenny might have ownership. What's the best way to prove that Jenny does not have ownership? If Jenny signs a what?
Quitclaim.
A quitclaim deed. She quits her claim. She's not claiming she owned it. She's saying, I don't know if I own it or not, but I guarantee I don't own it anymore. And what's she most likely gonna do?
Quitclaim.
She's gonna sign it, quitclaim it, take her $1,000 and go about her merry little way.
What would they sue Jenny for? What's if Jenny were to lose? What would she get? The ownership of the property?
If Jenny were to lose,
Yeah, so she doesn't want to sign it, and she's like, all right, take me to court. What's the...
Why would they take her to court? Because she is legally interfering with the rightful ownership rights of somebody in Indiana by refusing to sign that quitclaim deed. Because what she is in essence doing is now making a competing claim for the property. It's been brought to her attention that she either needs to make her claim or she needs to sign it away. And so they will file a lawsuit against her to force her to sign it away. But then if she loses, and she will, because they got 40,000 lawyers and all the documents on their side, when she loses, not only will she have to pay her own court costs, but she'll have to pay theirs too. And so it's just a lose, lose, lose for her.
What if she really owns 112 though?
Maybe she does and maybe she doesn't. If she doesn't have, here's what a judge is going to look at when she shows up in court. A judge is going to say, okay, Ms. Johnson, why do you claim that you have ownership of the property? What actions had you taken over the course of your lifetime to assert that you own this property? Or indeed, did you not know about this property at all until somebody showed up at your door and said this might be the case? Right there, she's buried right from the beginning. And that's why these things work. And that's why they exist. Because otherwise you would have properties that would get tied up forever and it couldn't be sold because you'd have these competing claims of ownership. Because stuff happens. People forgot to sign deeds. Deeds didn't get recorded. Documents got lost. It happens.
Can Jenny negotiate the 1,000?
Could she negotiate? Absolutely. And if she were smart, that's what she would do.
I would be.
Because if they came with a check for 1,000, they got another one in a briefcase for 2,000. Trust me. Now, she's not going to get a bunch of money, but she can definitely negotiate. Because they don't want to go to court either. Even though they know they're going to win. Because ultimately, their client in Indiana, what do they want to do with the property?
Sell it.
They want to get it sold. They can't sell it until this thing is settled. They want it settled. They want it over and off of their plate. And so they will do whatever this whole chapter makes you uncomfortable. Welcome to ownership.
It's some scary stuff.
It is. It is.
It makes me feel much less secure in the world.
It's all based on claims, and even the words are crazy. I mean, we don't think about it, but like all these words come from like old English law. Like literally, why do we call it title? Because you couldn't own property unless you had a title. You had to be a lord or a lady or an earl or a duke or a duchess. You weren't legally allowed to own property unless you had a title. And how did you get title if you didn't have it? You had to be granted title by the King of England. And the only way you could be granted title is if you did a good deed. That's where all the terms come from. So all of this mess is just nonsense in the first place. But it's the only system we got, so we're stuck with it. Okay? Ben likes it. And it is wishy-washy. It is, no doubt. Title is. It's a very mysterious thing. All right? Are we good on the different types of deeds there? So we got one, the general warranty deed, that makes all these guarantees from the grantor to the grantee, and it covers what period of time? What the guarantees are good for what period of time?
Forever.
Okay? Forever. We've got a special warranty deed, which the grantor only guarantees what period of time?
The time they owned it.
The time they own the property from any problems with title. And then we've got the quitclaim deed in which the grantor is giving no warranty at all. All right, y'all ready for quiz? Quiz time. One question quiz. Ready? Put your answer in the chat, please. What type of deed is best at transferring ownership in a transaction? What type of deed is best at transferring ownership in a transaction?
General.
All deeds.
Oh, all deeds transfer ownership.
It warms my cold heart to see y'all saying they all do the same thing.
That's a good question.
They all.
I so answered that one wrong.
Such trick questions.
You say which one is the best?
No, I said which one is best at transferring ownership. But as far as transferring ownership goes, they all
do the same.
Gotcha.
It's just some are better from the grantee's perspective because they have warranties with them or guarantees with them.
Can you add that as a bonus question to the test?
Yes, I will be glad to add that as a bonus question to the test. We mentioned what clouds or defects were. I think the most important word on this slide, and then we'll take a break, is the clouds or defects are potential problems. These are not definitive known problems. Sometimes when we research what we call research the title or research the ownership, we find potential issues that might be a problem. And that's when we would fall back to most likely a quitclaim deed to clear up the question of ownership. That's usually when quitclaim deeds come into the picture, is to clear up any questions. Because, you know, if Jenny signs that quitclaim deed with her as the grantor and the seller in Indiana as the grantee, then the seller in Indiana undoubtedly now has full ownership of the property, because the only thing that came up that said they might not have full ownership is Jenny's question. Well, now Jenny's question has been eliminated, so that now that seller in Indiana is free to sell that property and move on with their lives. And so that's where quitclaim deeds would be used most commonly. Some special purpose deeds that you don't really need to know much about are, you know, gift deeds if the property is being given away. We're going to talk about trustees deeds a lot in the finance section, so you don't need to worry about those. And also a deed in lieu of foreclosure. We're going to talk about those in finance. So these last two are finance, and we'll talk about them then. So you don't need to worry.
Travis, Anthony had a question about bargain and sale deeds. Do we need to know anything about that?
Yeah, you don't need to worry about bargain and sale deeds. No.
Gotcha.
You don't need to worry about bargain and sale deeds. Good question, Anthony. Okay. I think it's good for a break right there. Generally speaking, after we cover those different types of deeds, May said she needs time to decompress. We're going to take it. I got 8:05. How about 9:05? Okay. See you at 9:05.
All right.
Zoom. So picking up where we left off before the break, this is excise taxes, which was actually in your Chapter 3 math worksheet. It used to be in Chapter 3. They've moved it to Chapter 5. It really doesn't matter. And it makes more sense in Chapter 5 because it's a transfer tax. An excise tax is a tax that's paid at closing. So this is a tax paid at closing. Okay. And it's paid by the seller, not by the buyer in North Carolina. This is North Carolina specific. So if you get an excise tax question, this would be on the North Carolina specific section of the exam, not on the national section. This is a tax that sellers pay when they sell their property, and it is very easily calculated. It is the purchase price divided by $500. And the reason for that is the tax is a $1 tax for every $500 of purchase price. So you basically, what you're doing is you're breaking the purchase price down into little blocks of $500, and every $500 in purchase price gets a $1 tax. Does that make sense for everybody? Before I go into, because there's a little bit more fine detail to it, but this is really it. This is most of the information right here about it. It's a tax that's $1 for every $500 in sales price. So just kind of check your brain, get your brain locked in. If the property sold for $1,000, how much would the tax be?
$.
$2, right? Because it would be $1 for the first 500 and $1 for the second 500. It'd be a $2 tax. Does that make sense for everybody?
Mm-hmm.
And if it was a $1,500 sales price, it would be a $3 tax. And if it was a $2,000 sales tax, it would be a $4 tax. So this is not a big amount of money overall. Is everybody with me on this? So first lesson is, if you calculate excise taxes and it's like thousands of dollars, you probably did it wrong. Because it's $1 of tax for every $500 of purchase price. Now, there is one catch here. The state doesn't want this as a tax. They will not accept $198.62 as an excise tax. And they won't accept $198.02 as an excise tax. They want, as my grandfather would say, folding money, not change. They're going to always round up. So no matter whether the excise taxes you calculated were $198.62 or $198.02, what would actually be the tax that would be paid? How much?
$200.
$199.
No, it would be round up to the nearest dollar. So $199 or $198.
99. $199. They always round up. So it would be $199. No matter $198 and any change would be $199. Everybody with me on that?
Oh, hold on. So, okay, so even if it's $198.02, it still is $199?
Yes, that's right. That's what I'm saying.
Oh,
Always
okay.
round up. It's not
Got
rounding. It's going up to the next dollar. Okay? The tax has to be paid in whole dollars. Everybody with
So you said it was the purchase price divided by $500. So the purchase price of a house. So say your house is $500,000. That means the tax would be $1,000.
I mean, shit, 500. Yep.
Okay. Okay.
My brain's working ahead of me. Will be $1,000 tax.
Okay.
Exactly right. Okay. Purchase price divided by. Now, here's how they're going to try to make this hard on the test. This is Jenny's special statement right here. Jenny, they're going to tell you that the buyer is taking out a 30-year fixed rate loan in the amount of $372,000, and they're getting a note back from the seller for another $115,000, and they want you to calculate the excise taxes. How many of those numbers do you need? And the answer is none of them. Because the only number that matters when you calculate excise taxes is what?
The price of the house.
The purchase price. That's exactly right. So that's going to be, I mean, that's the only way they can complicate this on the test, is to give you a bunch of numbers you don't need. It's going to be purchase price. Everybody all right with that?
Mm-hmm.
Yeah.
I don't care if they finance it or they're paying cash or whatever. Now, this is an example here. As an example, $89,500 equals $179 in excise taxes. Well, what if it was $89,510 sales price? We would still do what with it? Divide it by what?
500.
500.
Divided by 500. And that equals, somebody got a calculator out? I know it's
179.02.
180.
79.02, but it would be what?
180.
Still would go up to 180. Because they always round up. Everybody okay with that?
Yes.
Now, the other way you can calculate this, and it doesn't really matter which way you want to go. I'm going to back up again. I'm going to erase this method.
1 second, Travis. I want to see if Michelle needs to screenshot that. Oh, never mind. It's okay.
Good?
Yeah, it's all right.
Because we're going to do it another way. If you got that same purchase price, and so I want you to understand this in case you see it the other way, that it's the exact same thing. You can actually round up before you divide. But in this case, you're not rounding up to the next dollar. You're rounding up to the next $500. If you round this number before you divide, you got to go up to the next $500. So that would go to $90,000 divided by 500, which would be the same $180. Or you can say 89,510 divided by 500 equals the 179.02, and then round that up to 180. It does not matter. Either way, the tax you calculate is going to be 180.
So Travis, like on our homework questions, when it would say a house sold for or market value, blah, 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 assessed value, and we had to calculate all that stuff.
Yeah.
We would use when it says market value, that's this, right?
Sales price. It has to say sales price. Because excise taxes are only calculated on sales tax.
Okay, it'll say what it sells for. Okay.
Yep. Yep. So this is usually when as we get later in the class, we'll start to calculate closing costs. How many of you have ever heard that phrasing, closing costs for parties when they go to closing? The buyer has closing costs, the seller has closing costs. This is a seller closing cost. This is the first example of a closing cost that's usually paid by a seller in a real estate transaction in North Carolina. All right, that's all there is with excise taxes. We talked about all the deeds before the break. Those were the voluntary forms of alienation. And I believe it was, I think it was Anthony who before the break said the big difference between voluntary and involuntary was whether or not the grantor wanted to do it. The will of the grantor. And that's exactly right. Now we want to shift gears to involuntary alienation. Involuntary alienation is a whole different form of alienation where the grantor is not a willing participant. Another way to say this is ownership, and alienation means transfer of ownership. So another way to say this is ownership is being taken away from the grantor against their will. Is everybody with me on that? So these are all the ways that ownership can be taken away from someone against their will. And yes, eminent domain is one of those, Ben. Absolutely. So Escheat, which to me, they could have just stopped at these 5 letters right here and have had just the same effect. And Escheat is when the state cheats someone out of their property. This is when a person dies, and you need to know this word right here. This is a vocabulary word you need to know. So just vocab. Make a flashcard, okay? Intestate means you died, what does it say right there? Without a what?
Will.
A will.
Without a will. I asked that question one time. Someone said without their intestines. I'm like, that is not what intestate means.
I would ask that.
Intestate means...
You're lying.
I'm not lying. Somebody actually said that. I said, when they die without what? Their intestines? No. They die without a will.
No, they come from.
Bless their heart. They died without a will. If you die without a will, the state will make one for you. And the state makes a will for you based on a pecking order. It's called the law of intestate succession. But basically the pecking order, and you don't need to know this for the test, but I'm just going to show you for purposes of, how this works in the real world. The pecking order starts with a spouse. If you die without a will and you have any, assets, then it's going to go to your spouse. If you don't have one of those, then they're going to look to see if you have children. If you don't have any of those, then they're going to go to your parents. If your parents aren't still alive, then they will go to siblings. If you don't have those, then they will go to aunts and uncles. And if you don't have those, the end of the line is first cousins. If you get here and we put a line through that one, then the state has done all they're going to do to try to find your heirs. They're going to declare that you died without a will and you have no heirs, and therefore all of your property now belongs to the state of North Carolina. That is an escheat. So people who die without wills, who don't have heirs that the state can locate, and as you might imagine, they look real hard for them too. If they cannot locate your heirs, then all property owned by the deceased person would become property of the state of North Carolina. And they will, of course, sell it, liquidate it, keep the money.
That's easy to remember because you say it's a bunch of escheat. And
Right, exactly. Exactly what it is. Exactly.
That's how I remembered it for the test.
Okay. That's all you need to know for an escheat. So a person, the big thing is someone dies without a will and then we cannot locate their heirs. Eminent domain is still the state taking. Of course, it could also be a county or a city taking, some government entity taking. Here in escheat, at least they gave you the dignity of letting you die before they took your property. Here, they're not going to wait. The state of North Carolina, the town of Cary, Wake County, Orange County, wherever you're located, has decided that real estate that you own as a private citizen needs to be public property. The public, us as a group, would be better served if your property were no longer private property, but were publicly owned property and were being used for benefit of the public. The most common example of this is when they build new roads or expand existing roads. Because very often, if you're building a new road, for example, that roadway has to extend through what is currently privately owned property. And the state needs ownership of that property. Well, you or I, as a private citizen, if you wanted ownership of property that I had, you would have to come negotiate a deal with me. Now, here's the big question. If you as a private citizen wanted to buy property from me, do I have to take the deal? Even if you make me a sweet deal, can I say no?
Yes, you can.
Sure I can. I can just refuse. I don't want to sell. It's sentimental to me. It's been in my family for 200 years. I don't want to sell it. And I have that right.
They're still going to.
If the buyer is a private citizen. I do not have that right if it's the state of North Carolina knocking on my door. If it is a government entity who wants ownership of that property, they have the right to, and that right is called eminent domain.
I actually have a story for that one. In my old neighborhood, there were two houses. I think they were like $300,000 and $500,000 houses. And the state was going to build a new road coming through. They took those houses and burned them down as a fire practice and never built the road. They never. That was 14 years ago. It still stands unused.
Unused. They have ownership of it though, and it's benefiting the public greatly, isn't it?
It looks good as grass, I guess.
They have this right. And you could sit back and argue, whether you like this or don't like this, a million different ways. But you need to understand for test taking purposes that government entities or agencies do have this right. And specifically in North Carolina, we are what's known as a quick take state, which means you don't even have the legal right to fight them in North Carolina. In some states, you can actually go to court and sue the state, and a judge could step in and stop the adverse possession. In North Carolina, there is no legal ability for a judge to stop the adverse possession. If they want it, it's theirs. Now, the only thing that, and there's the question, Isabella asked the question, the only thing that the state is required to do in this case is pay for what they take. Now, for test taking purposes, what they might ask for is the taking has to be for public good. So like in the case of a roadway, they have to show, that they're taking it for public good. It's going to benefit the public. And then here it says just or fair, that just means fair, compensation will be paid to the owner of the property. But here's where the rubber really meets the road on that. Who's taking the property?
The government.
The government. Who's deciding what is fair compensation?
The government.
The same people who are taking it. This is not a good recipe in a lot of cases.
What if you have a lien, like financing this land or something like?
Then you would pay off the lien once you get the funds that they paid you for the property, assuming that there were enough funds to pay off the lien.
Hey,
if you
but
don't have enough funds, are they gonna deal with the mortgage or the finance company? Or not?
Between you and the mortgage company to figure out. I mean, yeah, it could be ugly. It could be ugly.
Wait, so they can take your land, give you less than what you owe on it, and say, well, screw you, you get to figure that one out?
So, yeah, well, they could. And Anthony brings up a good point. He said, the lien runs with the land, so you could just take the money and never pay the lien off. Foreclose on the state. Of course, that might, my guess would be they would pay the lien off before they gave you the money, but that'd be my guess. But
that's what they did for us. They put it in escrow and then they pay off everything first.
They paid it off. Did they actually take your whole property, or did they take a portion of it then?
So it was portion of it, but we lost the whole property because they had to take our septic septic repair area, and they couldn't give us another. And the fight between us and them was, the literal fight between us was, my parents live with us and they had a separate apartment built onto the property, and everything assessed in this area with that, if you're experienced, everything that range is like $750,000 plus. And I told them, the house that I have, or that we have now, I was like, help us get that. It's not even close to what those are worth. And they're like, we don't have to.
Right. Well, one of the most famous cases of eminent domain in North Carolina history happened in Cary. When they widened Maynard Road years ago. There was a house in the corner of Maynard Road in Quitclaim where the owner, they widened the road. They took 20 feet of the front yard of all those properties along Maynard Road. And this one particular house in the corner, that made the front of the house only about 20 feet from the roadway. Historically, that intersection had also flooded. And so part of the road widening process was to elevate the roadway as well. Well, if you elevate the roadway so the road doesn't flood, where does the water go?
Runs back into the yard.
It goes back into the yard, right down the now very steep driveway. And so this house, not only did it flood in the front yard, it went under the house. There was standing water perpetually under the house. And so this gentleman made the argument that the town should have actually taken the entire property. Sounds a lot like what you were dealing with, Dan, which was that the portion they took made the whole property useless. Whether they actually wanted the whole property or not, the portion they took made the property useless. And that was his argument. And the town of Cary said, no, that's not true. And so he was very frustrated with the process. So he was an older gentleman. He couldn't do it himself, but he hired some kid to get up on a ladder, white 2-story house, and he spray painted in orange paint across the front, screwed by the town of Cary across the whole front of the house, right there on Maynard Road. And the town of Cary is very understanding of things. They sent him a notice that he was violating the town's ordinance against inappropriate signage, which carries a $500 a day fine for his inappropriate signage. So not only did they not pay him what he thought was fair, they started fining him $500 a day for his inappropriate signage on the front of the property. it got to be such an ugly battle. It was in the news. It was on the, I mean, it was national news, that the ACLU actually stepped in and defended him. The American Civil Liberties Union stepped in and defended him against the town of Cary. It took 3 years, but they finally won the case, and the town was forced to pay the full market value of the home prior to the taking for the roadway. The ugly part of the story is the poor man died before the thing got settled. So he never even lived the resolution of the thing. So that's like the most fitting end to an eminent domain story you could possibly, even when you win, you lose. I mean, it literally killed him, you know, so it just.
Well, dang.
So did his heirs get the settlement?
Yeah, his heirs got the money. Yeah. Meanwhile, for the last 2 years of his life, he lived in a house that was perpetually flooded and couldn't get out of his driveway. So,
Do you think that contributed to his death from like mold or whatever?
I don't know. I have no idea. But it's funnier when I tell the story to say they killed him. So I mean, that's the way I tell it. You know, whether it actually happened or not, I don't know. But I mean, that's a true story. That case was very famous eminent domain case. This is a very ugly process. There's just no way around it. Nobody likes to have something taken from them, and eminent domain is a taking. Foreclosures, that's obviously an involuntary process. If the property is foreclosed on, then ownership is taken via a lien foreclosure, which we talked about some already in chapter 3. We're going to talk about a lot more when we get to chapters 14 and 15. But that's just remember that is a form of involuntary alienation because ownership is being taken away.
Travis, quick question in regards to that. So me being a broker, should I look for anything that's going to be potentially becoming an eminent domain for a client of mine?
Particularly look at NCDOT's website. Look at plan right now. If you were selling property in Southern Wake County, you better be looking where 540 is going.
Right.
Because somebody could be buying a house that's directly in the path of, you know, that roadway, and that property could be taken via eminent domain at any time if it hasn't already been. So yeah, that's the kind of thing you got to be on the lookout for proposed roadways and that sort of thing. Okay. Adverse possession. So it would be only fair if we talked about a way the government could steal stuff that we gave y'all the same tools. So this is legalized theft. This is absolutely legalized theft of property, but not by a government entity. This is legalized theft by you or me or any other private citizen. The only difference between us and the government is it takes us a long time to steal something. They can do it instantly. And they don't run the risk of getting in trouble by doing it. We have to do it illegally for a very long time first. And then we might, basically, it's almost like we're going to steal it for so long that the courts are finally going to go, damn, just let them have it. That's what adverse possession is. Adverse possession is somebody who has taken real estate that does not belong to them, has used it just like it belongs to them, has acted for all the world like it belongs to them for so long that they're willing to walk into a court of law and go, yeah, it ain't mine, but it should be.
Does squatters' rights fall under this?
Well, this is sort of like the legal embodiment of the idea of squatters' rights. It's if you've been there long enough, a court of law could give you the legal right to own the property. Here's what it's based in. It's based in this legal idea that we expect the rightful owner to put a stop to it. We expect the rightful owner to step in and say, hey, you shouldn't be here. You're trespassing. Get off of my property. We expect the rightful owner will realize this is going on, will call the police, because remember I said you're doing it illegally, get these people arrested and get them off their property. But that has not happened for a very long time. And because it hasn't happened for a very long time, then this person might actually have the legal right to claim ownership of the property. Does everybody understand the idea before I talk about the specifics of what's going on here?
Rodney was just curious if there's a certain number of years attached to this process.
There is a certain number of years, Rodney, and you just flowed right into what I was going to say next. As I was going to say, shouldn't the next question be then, how long? How long? Because that's the magic question here, is how long do you have to do it illegally?
And Julia also asked a good question as well. Is this also when someone allows a person to live with them and can't get them out of their house because they've been there so long?
Julia, this is not that. Because the key word you said right there is allows, meaning with permission. Adverse possession means you never had permission in the first place. Adverse possession means you just took it over. You never got permission. You never bothered to get permission from the owner. What you're talking about is that are rights that are more directly related to tenants' rights, a little bit different thing. But this is just somebody who was never there legally in the first place. It's not they wore out their welcome. They were never welcome at all. They were just trespassers for a long time. And the answer.
Hey, Travis.
Go ahead. Go ahead.
Oh, no, go ahead and say what you're going to say. You might be answering my question.
Rodney, to answer your question of how long is 20 years. And we're going to talk about that, but it's 20 years. Go ahead, Melissa.
That was my question. My Zoom had kicked me out. Like I had to completely log back in.
That's all right.
So.
Yep. So,
okay.
All right. So this, and here's the keys here. It says by using the property, and what does this say right here? Without what?
Permission.
Without permission for a very extended period of time. Okay. Basically, if you go into court and you claim adverse possession, you're basically claiming that the owner of the property has abandoned the property. And here's what you're giving as proof that the owner has abandoned the property. Your Honor, clearly they've abandoned the property. I've been there for 20 years and they never told me to get out. They never even once knew I was there. They didn't notice, or if they did, they didn't say anything to me, and I sure as heck didn't ask their permission. So clearly, they've abandoned the property. That's the argument you would make in a court of law. And if you can prove that in a court of law in North Carolina, you will walk out the doors of that courthouse with ownership of that property. Okay? That is adverse possession. Now, what are the rules that they say you can memorize this on the test with this little ocean thing? Okay. Key here, it's got to be open. The use, the taking. In other words, everybody sees you're there. You're not sneaking in and hiding and blacking out the windows, and you're not just like, it's not like some 100-acre piece of land that's way back somewhere and like, oh, nobody knows we're back here. You are just big as day, just right up in there. I mean, you're so out in the open that if you ask, hey, Seth, who owns that property over there? Seth would say, Travis owns that property. Because, well, he must. He's out there every day. I see him out there every day. I mean, this has got to be out in the open. And people say all the time, well, how do you prove that? I don't know. That's up to a judge. But I'm saying this is what the rule says. It'll be up to a judge whether you had proved you had done it out in the open. Continuously, without interruption, for a minimum of 20 years. This is a big one. Exclusively. The word exclusive means only one. In other words, this can't be some property that everybody uses. If there's like some abandoned lot and all the neighborhood kids play on it, you can't claim adverse possession. I had a young lady in class one time, and in their neighborhood, there was apparently this little path that ran alongside her lot that people used to cut through to the neighborhood pool. Well, it wasn't on her lot, it was on the neighbor's lot, but that lot had never been developed. And she had taken upon herself to like take care of this pathway because it looked terrible. So she put down pavers and bricks and everything. And so we talked about this. She said, so does that mean I could claim this thing with adverse possession? I said, absolutely not. Because her use was not exclusive. What's the first thing she said was happening with this path? Everybody was using it. And a judge would say that's not a claim of adverse possession. And then
Good question, though.
I'm sorry?
I said, good question, though.
Good question, right. And so then it's also got to be without permission, without the owner's permission. It doesn't matter whether the owner knows or not. What matters is whether you have their permission or not. So if they give their permission, you can't claim adverse possession. Ben said, what if we're the ones running the kids off and making it ours, also a testament open? Then that would be a case, right? If they ran all the kids off and said, get off my property, even though it wasn't theirs, and they had been doing that for 20 years, that might be a case of adverse possession. Yeah. This happens, this does not happen commonly, but when it happens, fences are a big reason for it. That's one of the best ways to illustrate that you took the property, because you can show a date of, oh, we had the fence put up on this date. And it pretty clearly shows you took it exclusively because you fenced everybody else out. And if you didn't have permission when you did it, that's usually enough proof for adverse possession. And again,
So I have a question.
What is enough proof? That's up to a judge. That the judge decides if there's enough proof or not. These are just the rules that the judge is supposed to follow. Go ahead, whoever said they had a question, I'm sorry.
So does that include like encroachment with fences and stuff like that?
Absolutely. So Melissa, yeah, it's a great question. An encroachment could turn into a claim of adverse possession if it stays there long enough.
So when I built my house, the reason why I picked my lot is because I like the other lot better, but the other people have been there since like the 40s. And their fence was clearly on the property line of the neighboring lot, and I didn't want that.
Lost you for a second there. You didn't want that. You didn't want the fence, right? So yeah, if it was allowed to stay there, and didn't have permission to be on somebody else's lot, they could come back and claim adverse possession. And Ben's going to be just fencing up Wake County.
I have a question because I asked the guest teacher last time, but I just want to ask your opinion. So our wonderful sellers that didn't tell us about an HOA also didn't tell us about an easement on our property that nobody else found. And so there's a greenway easement, but there's a fence that's blocking it all anyways.
Right.
The fence has been there for a very long time. So that's where we would just do that same thing. We would just go fight it and say, obviously the fence been here for X amount of time. Nobody's using this part of the greenway.
So the easement has been abandoned potentially.
Yeah.
Same idea, which is, basically there's always a method to get rid of things that people have abandoned.
But does it matter that they got a survey done and they got permission basically to put the fence up? Because I'm sure
it would matter. It would be weighed in the decision, I'm sure. I can't say how a judge would come down on that, but it would matter, I would think.
Okay.
Yeah.
Hey guys, Isabella asked a really good question. She said, so if I find a vacant land and I put a mobile home on it, stay there for 20 years and fence it, it will be mine?
You got it, Isabella. As long as you can dodge prison in the meantime during those 20 years, it's all yours, Isabella. Got it. That's the problem is you have to recognize that during that intervening 20 years, you most certainly are breaking the law. So that's the downside to adverse possession.
If anybody needs a witness, Ben has you.
So Travis, does it apply to the entire real estate, the whole piece, or it could be just part of it?
Does it apply to all real estate or what? I missed the last part.
A whole piece of real estate, like the whole lot, or can I just apply
Usually it's going to be just the portion that was actively taken. Like, did they fence it? In other words, if I put up a fence and it goes 5 feet onto my neighbor's property line, I probably couldn't claim adverse possession of their whole lot. I could probably make a claim of adverse possession of that 5 feet.
So that's very similar to encroachment then.
Yes, well, that was Melissa's question. She said, well, if there's an encroachment, could that become this? And yeah, if an encroachment stays in place for 20 years, it could become adverse possession.
Okay, so they are kind of related then.
They are related, absolutely. Because an encroachment is an illegal use of somebody else's property. Well, this is just taken to the extreme of you've been doing that for 20 years.
Thank you.
Yeah. Okay. Don't worry too much about transfer of property after death. I don't think you will see questions about that on either the national or state test about differences between whether it's been transferred by will or by intestate succession. I don't think you need to know a devise or a bequest. I think you can just skip over all that. You do need to know this slide though. We do need to talk about title assurance, and it'll be the last, kind of topic we have for tonight is how do we know we have good title? Well, we talked about the different kinds of deeds. If you're a grantee, what kind of deed would you prefer to get because it comes with more guarantees from the grantor? Which one would you prefer?
The general warranty.
Oh, I know this. It's general.
General warranty, yes, that's right. If you're the grantee, you would definitely prefer a general warranty deed. But here's the problem. Even with a general warranty deed, the only guarantees you have are from the grantor. What if you can't find them? Or what if they're dead and their children are broke? It's kind of hard to get blood from a stone, so to speak. What if there's just nobody to sue or they don't have any money? Those guarantees might not be worth a lot. Does that make sense for everybody? That there's a chance that even if you get the guarantees aren't they aren't worth a lot, right? I mean, it's like having a lifetime guarantee from, Craftsman Tools. Well, Craftsman doesn't exist anymore. It's just a brand at Lowe's, but you can't go and replace. They won't back it up anymore because the company that was behind it, which is Sears, doesn't exist anymore. Okay, or free rentals at Blockbuster. There you go. You can't claim them. You got their guarantee, but you ain't gonna get them because the company doesn't exist anymore. So there's always the worry that we could have a title problem, even if we have a general warranty deed. We want, as a buyer, a grantee, we want something called marketable title. Marketable just means it has no serious defects, no flaws, no clouds on the title. Marketable title means that there is we've done the research and we don't see any problem with the title to this property, no potential problems at all. And that's the kind of title that we want the seller to convey. As a matter of fact, most sales contracts say that the seller is agreeing to provide marketable title with a general warranty deed. It's usually all spelled out in the sales contract. That's what they want. But even so, we don't trust them. We just don't place that kind of blind trust in anybody any longer. And that's why we do something called a title search. A title search, and we generally don't do it ourselves, though we could, is the process of researching in depth every transfer of ownership that's ever happened with that property. In theory, all the way back to the beginning of time. So when we're talking thousands of years, in theory, we want to know who owned this piece of land 27,000 years ago. That in theory, I keep saying in theory, because is that going to be practically hard to do? Is it going to be practically hard to keep going further and further back in time?
Yes.
Eventually, we're going to run out of documents. We're going to run out of stuff's going to be missing. It's just not going to be there. We're going to run out of documents. Okay. But in theory, we want to go back as far as we possibly can and see this clean transfer every single time. If there were 4 owners, we want to see 4 signatures on that deed. If it was a married couple, they better have both signed it. That's the kind of stuff we're looking at every single transfer. And we don't usually do that research ourselves, though we can. This is why we hire closing attorneys. One of the main functions of a closing attorney is to do this title search, to do this research. Now, let me ask you a serious question here. Who's worried about getting good title? Is it the buyer or the seller? Who's worried about what they're going to get?
The buyer.
The buyer. So if the closing attorney, if one of their biggest jobs is to make sure we have good title, who are they representing? Who are they working for when they're doing that search? Are they working for the seller or are they working for the buyer?
Buyer.
Working for the buyer. They're doing all this research on behalf of the buyer to try to come along and find any potential issues. And that's what we're going to go through, and they're going to look at this thing called the chain of title or chain of ownership. And that's
Can you go back for 1 second before
to that or that?
Travis, really quick. So the buyer hires a closing attorney, or one automatically works with the real estate agent?
The buyer chooses one.
Okay.
The buyer chooses one, often at our suggestion.
Okay.
Yeah. Okay. So most buyers are going to hire a closing attorney to come do this title search for them to protect them. Because if we hire somebody who's a legal expert to do all this research and they don't find any problems, we as the buyer feel much better that there are problems. Anthony, be nice. Anthony said you needed this slide. This is the one you needed.
Wait, you didn't get him long enough.
I didn't give enough time. So the attorney is going to be hired to provide what's called an opinion of title. An opinion of title comes from an attorney. In their opinion, do we have good title? This is the first thing that we as real estate agents absolutely cannot do for our clients. We cannot give them an opinion of title. If a buyer or seller or anybody ever asks you, if they ever ask, do we have good title? It is immediately time to send them where?
To an attorney.
To an attorney. In North Carolina, only an attorney is legally qualified. Now, the truth is, can I do a title search? Yes, and probably better than most attorneys. I'll be honest with you. But I'm not legally qualified to do one. I don't, that is a legal service in this state, and I'm not licensed to do that. So I would have to refer them to an attorney for it. I've actually had attorneys who call me regularly and say, can you help me with this? I'm like, aren't you the one with the license for this? Can you take the bar?
Most paralegals do the title search for the attorneys. Attorneys just
right. Most of the time, the paralegals do it. You don't want a closing attorney doing your title search. Let the paralegal do it. They know what they're doing.
What you done ordered now?
Yeah. I'm sorry. What was that?
What is it?
Okay. So now, let me ask you this question. Here's a question I got for you. Is it hard to go all the way back to the beginning of time? We talked about missing documents and deeds not there. Is that going to be a problem?
Yes, it is.
In other words, if we go back far enough in time, isn't pretty much every property going to have a title problem? Aren't we going to eventually get to a point where we just can't document stuff any further back?
Yes.
So we need a way to fix that. And the state of North Carolina has a specific law. Every state has a law like this. They're all very similar. This is ours. And the only thing that would be different would be the amount of time from state to state. There's a chart in your book. So, and you got to memorize each of the 50 states and what their time period is. Okay. So that you need to do that this weekend. You got to know in all 50 how many years. Yeah, I'm kidding. You don't have to know that. You only need to know how long in North Carolina. In North Carolina, Anthony's on a roll tonight. Goodness, what did they put in your coffee over there, Anthony? I don't know, but he is fired up tonight. The Marketable Title Act in North Carolina says that you have 30 years to step forward and make your claim on a property. That if you actually want to be recognized as the owner of the property and you think you have a right, you better step forward within 30 years or you don't have a claim anymore. And I'm going to say that again. The state of North Carolina says, if you think you have a claim, if you think you own a property, how long do you have to go to the county courthouse and claim ownership of that property?
30 years.
30 years.
30 years. And if you don't make that claim within 30 years, then even if you've got a legitimate claim, it's not legitimate anymore because the state of North Carolina says you waited too daggum long. Is everybody okay with that?
So,
Yes.
yeah, well, I have a question about that.
Sure.
So if you pass away, your heirs take it, they never go redeed, or they never not redeed. They never deed the house again in their name.
They never record it.
They never recorded it. They're living in the house 20 years, 30 years, 40 years. They've never recorded it. So have they lost their right after 30 years to be the owner of that house because they never went and deeded the house in their name?
Somebody else goes and makes a claim of ownership, they have. If somebody else were to figure out that they had never recorded their deed on that property and it was sitting there with what we call an open deed because nobody had ever recorded their deed, and they went to the courthouse and recorded one, they would be the owner of that property as far as the law is concerned, because what the state of North Carolina would say is this claim is too old. You have 30 years to act on this and you didn't do it. Sorry, we're not going to recognize it.
But
Travis,
it could be adverse possession, like Ben said, because of the fact that your kids, for this example, your kids have been living in that house for 30 years.
And there could be all
so nobody else can put a claim on it.
There could be all kinds of competing legal claims, and that's where you're trying to play judge, jury, and executioner. Don't worry about how these things interplay with each other. Just worry about, do you understand what it means that a 30-year-old claim is dead? It just, the claim is too old.
So after 30 years, if somebody passes away, you have 30 years to stake your claim and change that over between you and your 12 cousins.
Right.
If you want a part of it.
When somebody passes away, but any claim of ownership, if you don't make it within 30 years, if you buy the property, nobody's going to twist your arm and say, go record that deed. But if you don't, you got 30 years. Otherwise, nobody's going to recognize it when you try to record it later on down the road.
Will there ever be a situation where a closing attorney doesn't go file the deed like they're supposed to?
It has happened.
And then what happens with the owner later?
They better go they better figure it out and go record it themselves or get somebody else to record it for them.
Or you could have a closing attorney that never paid for your title that you paid for 10 months after you bought the house on top of all your other issues.
So what I would say is, as a real estate broker, I always tell my buyers at closing, you should get a copy of your deed back from the county courthouse within a couple of weeks showing that it's been recorded. If you don't, let me know. And then I actually put on my calendar for a month after closing to go check and make sure the documents are recorded. I actually go look them up to make sure they were recorded for this very reason. So stuff doesn't get forgotten.
Don't they usually tell, like, my closing attorney has always sent me an email, like, confirming the deed's been recorded.
Recorded, right. Yeah. Everything's recorded. They usually do. Absolutely. Now, here's the real question here, and this is going to be where the rubber meets the road on understanding this topic. If I told you, go research that title, find every problem you can find, unless the problem's more than 30 years old, then we don't give a shit about it. How far back would you go with your search?
30 years.
30 years. As far as back as you possibly could.
But practically, how far do you think?
30 years.
30 years.
They go 30 years. They go 30 years because the effect of this law is that anything before that, any issue that would come up before that, doesn't matter.
Relevant.
It doesn't matter. So right now, if you go hire a closing attorney to get a title search done, they're probably only going back to 1990.
Well, Travis, does the age of the home matter with this?
The age of the home does not matter because the land is all the same age.
Okay.
It's the land that's been deeded.
I think that would answer John's comment in the chat.
Hey, Travis.
John, well, actually, John's comment, question's a good one. He's buying a house that was last transferred in 1954. Does that mean I shouldn't really need a title search? And he's not asking for an opinion of title here. What it means, John, is there's no need to look past the current grantors. You still need a title search because title searchers look for things like, did the grantors get married? Did they get divorced? Did they place any liens against the property while they've owned it? but there would be no reason to look at the previous owners because anything the previous owners did would have been far too long.
Hey, Travis, what about a will that's like 30 years within?
What about what?
Will?
A will?
Yeah, does that override? Does that have the same rule of 30, go back 30 years? Like,
what do you mean does a will have the same rule as go back there? I'm not sure what you're asking me.
so let's say you have a property and you said, I want this property to go to my next door neighbor, but this was made this will 35 years ago. Does this
That's
rule?
not when the claim on the property, that's not when the clock starts. If the property was transferred via will, when is the will actually executed? When the person what?
Died.
When they die. And so that's when the 30-year window would start.
Oh, okay.
That's when they should have recorded the deed. Okay?
Travis, really quick question. You made a comment just now that it didn't matter how old the house was, the deed belonged to the land. So the deed is for the land and not the house, or for?
Well, remember the definition of real property is land and everything permanently attached to the land. So the deed is always for the land. The fact that there's a structure attached to it is just along for the ride.
Okay.
Deeds are for land. Okay? Does everybody understand the Marketable Title Act? It's basically just a clean out the closets rule. It basically says, it's so old, throw it away. Don't worry about, why would you research a deed from 1865? Nobody cares what happened back then. Oh, but I found a mistake. Nobody cares, man. It's too long ago. That's the Marketable Title Act.
Especially if you can't even prove it, but go ahead, sorry.
Well, and that's the problem. When they get so far back in time, they're almost impossible to resolve. And so the state legislature recognized that, and they basically just picked a number out of thin air and said 30 years. No need to search any further back than that because we're not going to enforce anything further back than that. That's all it means. And the last thing is title insurance. Title insurance happens because we don't trust grantors. If we trusted grantors, we wouldn't need title insurance. Especially those of the grantors that give us a general warranty deed. We wouldn't need title insurance from them. But we don't. We hope we don't have a problem. We think we won't have a problem. We get a closing attorney to do the research to hopefully find any problems, and they didn't find any, but we still gonna buy insurance. You don't buy insurance in case things go well. Why do you buy insurance? In the event things go what?
Wrong.
Wrong, bad. You buy life insurance in case you die. You buy health insurance in case you get sick. Buy car insurance in case you wreck the car. You buy title insurance in case you have a problem with your title. If you have a title insurance policy, you don't need to go find the grantor and get them to come back and do your dirty work for you. You would simply contact your title insurance company. When do you think you buy title insurance?
Before you buy.
Before you buy the home?
How about when you take title? You're insuring your title. So you buy it when you take title. How long do you think title insurance is going to last?
Hopefully as long as you own it.
As long as you have title. So as long as you own the property. How often do you think you have to pay for a renewal on it?
Just one time.
None.
None. You buy it once. That's right. One time. No renewals. The day you purchase is the day you buy title insurance. It's one time. It covers your title for as long as you have owned the property.
Travis, I have a question about that.
Yep.
If it covers you the whole time, then why, when you refinance, do they make you buy another title policy, even if it's only like a year later?
Because it only covers the portion that covers you lasts as long as you own the policy. Generally speaking, if you have financing on the property, the lender is also requiring you to buy title insurance to cover them. And your title insurance that you bought to cover your previous lender doesn't cover your new lender.
Oh, so they don't make you buy the whole thing. They only make
They don't make you buy the whole thing. You're not rebuying the portion that covers you. You're only buying the portion that covers the lender. Yep. Okay. And we already talked about recording title and the necessity for recording. That's how you make your claim on property, and you publicly say you own it. And that is it for Chapter 5.
Travis, I have a question
Turned down for
about.
what?
Yeah.
I
So
have a
hang on just a second, maybe. Let me say this, because I'm sure people need to get going because it's 10. So I will send you an email with your homework.